or Lordship. Lordship. It's
Tomorrow, come tomorrow. It will be taken.
only on apprehension I'm mentioning a Lordship.
No problem. Already it is mentioned. If any extension mention, I will take
Your,
it.
your lord.
One.
My lord, under extenuating circumstances, my lord, may I have your lordship leave to mention item number 15, my lord? Although this is not the way your court functions, my lord, suddenly there has been a medical emergency at my place. My lord, I have updated, my lord, the learned advocate on record for the plaintiff, my lord. If only your lordship accommodates me for the day, if the matter is taken up at
Which
during
one?
item number 15, my lord.
Of the commercial?
Yes.
Who is for the defendant?
My lord, I am for the defendant. Plaintiff's advocate on record is Miss Shanonda Ganguly. I have contacted her over phone. She said that she could not, she will not be in a position to attend during the mentioning. But definitely, if it is taken up or if it is called, my lord, she will update the court.
Okay. If it is called, please mention it. Okay.
Your lordship, with your leave.
I will
Much
sit.
obliged.
Your lordship,
Much
with your, I am mentioning a matter for extension of the interim prayer. Your lordship, there is no interim returnable date given in the order, your lordship. The interim prayer will expire on 28th.
Huh?
On
28. Today we are on 26.
your lordship, there is no returnable date in the order.
No, what is the date of 28? Na?
28 is the last day of.
28 mention on that day. If it is not listed, I will take the matter.
Lordship, kindly leave to Lordship, one matter is already appearing as a monthly list item number 120, Lordship. The application for Order 7 Rule 10 was rejected by your Lordship. Now they have preferred an appeal. Our application for judgment upon admission, it's pending, Lordship. It's item number 20. If any day can be taken.
Item number?
120 of the monthly
Main
list. Monthly list.
Monthly list.
Lordship.
Who is for the other side?
Lordship, I am mentioning upon notice, Lordship. It's already.
The other side. Is a commercial
Mr.
matter?
Dheeraj Gupta, Lordship.
It's a commercial matter?
No, Lordship. It's a normal.
Non-commercial.
Non-commercial.
Let it tomorrow come. The day after tomorrow is to be mentioned.
Deeply obliged.
Inform the other side.
Lordship.
Yes.
May I have your lordship's kind?
Senior. Who is senior? You are senior?
May I permitted to mention, Lordship, probate matter. Scrutiny is completed, Lordship. 2024 matter. Prayer is issue citation, special citation, and another is publication in the.
Not done.
No, Lordship. The first time scrutiny completed.
Okay.
Two matters there.
4th December.
4th December. Lordship.
Yes.
Testamentary matter, amendment order was passed, amendment order it was submitted within time, but carried out not within time. Not a fault, one document was not correctly placed. So, deeply granted the
For what?
the proposed amendment.
One
typographical mistake, so they are not able to carry out that.
So what the court has allowed, what was the your proposed amendment that has been ordered passed by this court? Yes. So what you want now? Further amendment?
No, not further amendment. A line was not added, in original petition it was there, but in proposed amendment that line was not added. Only leave is granted to be mentioned every day.
5th December.
My lord, may I be permitted to mention the matter for inclusion is a testamentary matter as for the issuance of general and special citation.
5th.
My lord, if it can be kept in tomorrow's list.
Tomorrow there are so many matters are there.
Right.
May I have your lordship's kind leave? Your lordship had passed an order in PLA matters on 21st of November. And your lordship remembers that the apostille document, lordship has recorded in the last paragraph, third last paragraph, last line, it is not necessary in the application that the consent of the legal heirs to be apostille. Lordship, the consent was already apostille. Your lordship had declared that the application was not.
No, application is mentioned, not mentioned.
No, your lordship, I'll just hand over the order with the slip. There are two orders similar. And this is the third last paragraph with regards to the affidavit of legal heirs. It is found that the affidavit of consent filed by the legal heir, Rana Ghosh and Rudra Ghosh, Deep Ghosh, has been apostilled. It is not necessary in the application that the consent of the legal heirs is to be apostilled. Accordingly, the affidavit of consent submitted by the legal heirs can be accepted.
No,
But
kindly,
they were-
kindly come, page number 2,
Yes.
last third paragraph. With regard to the affidavit of legal heirs, it is found that the affidavit of consent filed by the legal heirs, that is so and so, have been duly apostilled.
Yes.
Correct. No. It is also not necessary in the application that the consent of the legal heirs is to be apostilled.
Yes, Your Lordship, they were not, that was not an issue. It had been, it is there. They were asking that the application be apostilled.
So that's why it is written. It is
Right.
not necessary in the application. It is not necessary in the application the consent of the legal heirs is to be
The
apostilled.
Lordship had declared that the application need not be apostilled. That is why I had mentioned.
It is not necessary in the application the consent of the legal. What further is to be required?
Just that's the application need not be apostilled.
Correct.
That is why I was stopped. The consent and the affidavits, all of them are apostilled. Only the applicant, since there is no affidavit there is only verification is required. The department is asking that let it be also be apostilled. That is why I mentioned before, Your Lordship. Your Lordship, upon considering what I had submitted, said that please produce the marriage certificate, an apostille copy of it, which will show the address.
What further required?
It is that was exactly the problem, Your Lordship. The application need not be apostille. That was the only direction I prayed from, my Lordship. The subject to being corrected, Your Lordship had said that. It has gone down as the consent being apostille because the consent is already there. Your Lordship has recorded it.
Consent in the application.
Yes, Your Lordship. Kindly, the application, the last line, it just has to be the application need not be apostille.
Yep.
Kindly, the same order, this different matter. Your
For
Lordship.
correction. Yes.
Wait for it.
Yes.
May I have your lordship's kindly to mention? It is TS 30 of 2015. Your lordship, this is the specially assigned matter before your
TS?
lordship. Specially assigned matter before your lordship. TS 30 of 2015. Your lordship, this matter has been extensively heard before your lordship. It is just 2 more dates are required for completion of the all proceedings of this order.
Which
it is
matter?
running in the list, but kindly fix a date and time, your lordship, for this order.
The date is fixed.
My lord, it is going down day by day.
Huh?
Just it is going down in the list day by day. Just 2 dates are required for argument and for one for a reply. Just 2 dates and time, your lordship.
List में है. Okay. It come tomorrow. I will see if it is in the dawn. I will take up.
You are mentioning for inclusion in the list. We had filed a commercial suit. We later realized it is a non-commercial suit. So we have filed it, but it has not been listed. It has been.
Yes.
It was filed in the first week of November, but it is yet to be listed.
Before the commercial division.
We are withdrawn from the commercial division. My lord, we had filed before the regular bench.
Ah.
And after that, it has not been listed, my lord. So just bring for inclusion in the list. It has been filed.
For what? Presentation of plaint.
Yes, my lord.
No, this is a non-commercial suit for presentation of paid leave under order to rule 2. But the client is the plaintiff is
Non-commercial?
non-commercial. Man.
Why it is not coming in? Why that? No, why the department is not giving?
I'm grateful, my lord. I'm grateful.
Yes.
My lord, indulgence, my lord, not any matter, my lord, not request your lordship, not if it commences, my lord, the matters, my lord, which have fixed time, my lord, for hearing, my lord, if all those matters, my lord, could appear, my lord, together in one place, my lord, maybe at the bay. So, my lord, it becomes very convenient, my lord, for us to see, my lord, otherwise, my lord, you have to see the entire list to see whether the matter.
Okay.
I'm very grateful to your lordship.
Do that.
Your Lordship, I am appearing on behalf of the respondent number 1 and 2. Your Lordship, I am led by Mr. Devraj ji in this matter. I am praying for adjournment today.
Why it is mentioned today?
Your Lordship, due to personal difficulty.
Your lordship, we are for respondent number 3. My lord, I am appearing for the
Your Lordship, the matter had to be renumbered to an IPD matter since it's an IP commercial matter.
So I am for the plaintiff petitioner.
Where is the suit?
Plaintiff order.
Yes, only I am releasing this. This is a commercial matter.
2024, your lordships.
I am releasing it and directing to give the IP number and to place before the appropriate court.
Yes, sir.
So and so appearing for the plaintiff, so and so appearing for the defendants. Full stop. It is fine from the record that this matter relating to the intellectual property and filed in the year 2023. Thus, this court is not having determination to hear the matter. Accordingly, CS number CS Com 503 of 2024 within bracket old CS number 89 of 2023 along with all connected applications are released from the list of this court. Full stop. The department is directed to assign the IP number in the suit and to place before the appropriate court, appropriate bench having determination.
Here we have for the plaintiff, the other side, other friend, was
Lordship,
supposed to take an instruction, with regard to the amount, if your lordship recalls,
Lordship,
Yep.
learned counsel appearing for the defendant respondent has not come to court. He is not well. Kindly not today, Lordship. Only not today.
Have you not taken instruction?
At
I'm not.
their behest, time was taken last time,
Correct.
They admitted that they want to pay. It was only with regard to the amount. And your lordship had kept the matter today specifically on their prayer,
Only not today, Lordship. Kindly.
From Friday.
It's Friday, for orders.
Not today.
Grateful,
Record an order.
Kindly raise.
Sense appearing for the plaintiff, sense appearing for the defendant. As per the prayer made by the counsel for the defendant, the case is adjourned. Let the matter appear on 29th November under the same heading.
Only one thing, no further adjournments be taken, We have taken several adjournments before,
May I have your lordship's kind leave,
Yes.
A suit for recovery of money, declaration and consequential reliefs. Your lordship kindly takes the prayers. The defendant is within. Hence, I am not praying for clause 12 leave of the latest patent, only praying for dispensation under section 12 capital A of the Commercial Codes Act. Lordship will find the averment, the pleading at page 12, paragraph 31 of my plaint.
So how the surface will come in?
Yes, the bar under section 34 of the Securitization Act will not apply.
Why?
Because I am challenging an action taken by the bank under the Reserve Bank of India guidelines to declare my account as a non-performing asset. If action is taken under the, I can come to your lordship, but the bar under section 34 will not apply. In my humble submission, the reason being, but I am not challenging any action of the bank, which can be challenged before the Debt Recovery Tribunal. But kindly see the Securitization Act section 34 once.
Yeah, surface act there. Right.
বললাম না আমার কাছে একটাই আছে নেই মনে হয়
hold on, नहीं है हाँ? अरे मेरा वो आदमी क्या मास्क लिखे हुए yes
Yes, well, there are two limbs in section 34.
Hmm.
One is institution of a suit, and the second limb is grant of an order of injunction.
Correct.
Well, the provision bars institution of a suit if the suit is subject matter of an issue which falls within the exclusive jurisdiction of the debts recovery tribunal or within the jurisdiction of the debts recovery appellate tribunal. My suit does not encompass an action taken by the bank under the Securitization Act, because I am only before your lordship,
What is the notice?
the securitization notice,
Yes, annexure Q,
annexure Q.
annexure L and annexure Q.
Yes, lordship. Q is at page 150, volume 2 of the plaint. This was issued to us on 8th of October 2024. একটা বই দিন না।
Yes.
Yes, kindly takes page 122 of the plaint. This is the impugned notice of 6th of December 2023. Page 122. This was issued by the bank's advocate on 6th of December 2023. My lordship will kindly comes to page 123, the last paragraph. You have used and utilized the aforesaid credit facilities but failed to comply with terms and conditions of the same and failed to repay the loan amount as per the agreed terms and conditions, as a result of which the aforesaid loan account has been classified as a non-performing asset on 29th of November 2023, and as such there is due and outstanding in the aforesaid loan account as follows. Now the particulars have been provided. Now lordship will kindly take the prayers. Yes, first is a prayer for money decree, but I am only on the declaration that my account has been illegally classified as an NPA with effect from the date mentioned in the notice. But this does not come under the purview of the Securitization Act. Next is, if lordship will see prayer D, E, though these are consequential reliefs. If lordship sees D, declaration that the legal notice dated 6th of December that I read out is illegal, null and void, and also all steps taken in pursuance of
where
prayer D, page 14 of my plaint.
Prayer.
Yes, I'm sorry. Prayer D, page 14, declaration that the legal notice dated 6th December 2023 being annexure M hereto is illegal, null and void, and all steps taken in pursuance thereof and in furtherance thereof are also illegal, null and void. Perpetual injunction, prayer E, restraining the defendant, its men, agents, assigns from taking any step or further step on the basis of or in furtherance to the legal notice dated 6th of December 2023 being annexure M hereto. Mandatory injunction, praying for withdrawal of the notices of 6th of December 2022 and the other two notices since there are consequential relief. Now if lordship will take section 34.
Yes.
Yes, lordship has section 34 of the Securitization Act.
Yes.
Kindly see no civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which a debt recovery tribunal or the appellate tribunal is empowered by or under this act to determine. So issues squarely falling within the jurisdiction of the debt recovery tribunal and the appellate tribunal, if those issues are the subject matter of my suit, then the bar under section 34 will apply. Now, Malad, the second limb is, and no injunction shall be granted by any court or other authority in respect of any action taken or to be taken in pursuance of any power conferred by or under this act or under the Recovery of Debts and Financial Institution 1993.
Correct.
Now, Malad, if my suit encompasses issues which are not the subject matter of the jurisdiction of the debt recovery tribunal or the appellate tribunal, then, my lord, in my humble submission, the bar under section 34 will not apply. And even, my lord, the vires
That
of
is correct, but we kindly come to your prayer EF. Mandatory injunction directed defendant agent representative from force to withdraw the notice dated
6th of December
2020, those issued by the defendant under section 13. Where is that notice?
Yes, 13.2 notice, my lord, is there. Well, I have disclosed it. Yes. It's in volume 2, my lord. Page 125, volume 2.
Yes.
Yes, again, my lord, I will just draw reference to that notice where it has been indicated that my account was declared as non-performing asset with effect from 29th of November. My lord, same, lordship will find that at page 125 bottom.
Just a minute, let me see this notice.
Yes.
Yes, then?
Yes. Now, my lord, the 13.4, lordship will find that at page 125.
13.4, that I am there on.
I'm sorry, 130, but 125 is the section 13.2 notice.
Correct.
And, my lord, the 13.4 notice, lordship will find that at page 132. 3rd of May 2024.
What is the 127? This is also 32.
My lord,
127.
separate notices have been issued to the borrowers and guarantors.
Correct.
The notice at page 127 was issued to the borrower, and the one previous to that page is to the guarantor.
Correct.
But the 13.4 is at page 132.
Yes.
Yes. The 13.2, thereafter the 13.4, all these two notices are a consequence of my account being declared as a non-performing asset with effect from 29th of November 2023.
Correct.
Now, my lord, I am an MSME unit. Now, my lord, the Reserve Bank of India has framed a circular with effect from March 2016 that, my lord, if my account is declared as SMA1, SMA2 or SMA3, now, my lord, if all financial institutions are required to take recourse to a corrective action plan. My lord, they require to restructure my account. They should take steps in aid of restructuring. Only if the restructuring process fails, my lord, it is only thereafter that, my lord, in terms of the framework, then they can proceed for recovery. Now, my lord, the Supreme Court in 2024 has delivered a judgment where, my lord, the Supreme Court has categorically said that the framework of March 2016 has the statutory force and it is binding. But kindly see that judgment once. Yes. But this is 2024 SCC Online SC 1864. It was delivered on, my lord, 1st of August 2024. I'll only read out two paragraphs for your lordship's convenience. My lord, paragraph 13 and 18. Paragraph 13 and 18.
Yes.
Yes. Yes, but kindly see paragraph 13. In view of the above, it is absolutely clear that the instructions for the framework for revival and rehabilitation of micro, small and medium enterprises as notified by the central government VD notification dated May 29, 2015 in exercise of powers conferred under Section 9 of the MSME Act as revised by the Reserve Bank of India notification dated such and such, and the master directions, that is Reserve Bank of India lending to MSME sector directions 2016 issued by Reserve Bank of India in exercise of powers conferred by sections 21 and 35 of the bank having statutory force are binding to all scheduled commercial banks licensed to operate in India by the Reserve Bank of India as stated in the said directions. It cannot be gainsaid that the Banking Regulation Act basically seeks to regulate banking business and mandates a statutory, comprehensive and formal structure of banking regulation and supervision in India. Section 21 and 35 of the Act empowers the Reserve Bank of India to frame the policy and give directions to banking companies in relation to the advances to be followed by banking companies. Such directions have got to be read as supplement to the provisions of the Banking Regulation Act and accordingly are required to be construed as having statutory force and mandated. But this is if the bank acts contrary to the framework of 2016, that's acting contrary to law. So that's illegal. Now, my lord, if lord, so far as the issue of presentation of plaint is concerned, my lord, 2018, my lord, a similar circumstances arose where, my lord, a suit was filed against a bank.
That is, see, with regard to the notification restructuring, your account has made NPA, that is correct. But once the bank has issued the notice under 13.2, 13.4 to you, and how the suit can lie, you can go to the DRT and take all the plea before the DRT.
But declaration, perpetual injunction, damages.
That is different thing.
Yes, that is what. If DRT, my lord, is not empowered to pass those directions or the decree that I am praying before your lordship, my lord, then those issues cannot be subject matter of the Death Recovery Tribunal or the Appellate Tribunal. Then the bar under Section 34 will not apply.
Correct.
If lordship sees the first limb of Section 34,
correct.
It says,
yes,
Section 34 once, my lord,
no court shall have a jurisdiction proceeding in respect of the matter, death recovery tribunal, appellate tribunal
yes,
empowered.
any matter which a Death Recovery Tribunal or the Appellate Tribunal is empowered by or under this Act to determine. So if the Death Recovery Tribunal is empowered by the Securitization Act to determine or is empowered by the Securitization Act to decide the issues, then, my lord, I should go before the Death Recovery Tribunal and cannot come before your lordship because the bar under 34 will apply.
Correct.
But here, my lord, I am praying before lordship. Lordship sees the prayers, declaration, money decree, consequential reliefs, which the Death Recovery Tribunal or the Appellate Tribunal is not empowered to pass. Because the Securitization Act and the Recovery of Debts Act, my lord, do not empower the Death Recovery Tribunal to pass such directions or decrees.
That's correct. But simultaneously, you see, once the bank has initiated a process under the SARFAESI Act, how the court sitting in the civil jurisdiction can enter.
But that has also been decided by a division bench of this honorable court. Delta yes. This is Delta International. This was is reported at AIR 2018 Calcutta page 8.
Yes.
But I would only humbly beseech your lordship to kindly see the first paragraph of the judgment. But what was the background of the matter that compelled the plaintiff to go up before the division bench? But this is one of the rare appeals that has had to be heard and dealt with without reference to the respondents, since the respondents had no right of audience at the stage that the order impugned was passed on July 24, 2017, in course of the trial court considering the appellant's prayer for granting leave under clause 12 of the latest patent. The leave sought was declined on the ground that the court did not have any jurisdiction to entertain the suit, not only on the ground of territoriality, but in view of an express prohibition on civil courts by statute. Now, my lord, kindly comes to my lord, paragraph 4 of that judgment, my lord. It may also be noticed at the outset that the appellants may have made a clean breast of things in the plaint in averring as follows at paragraph 44 thereof. All of a sudden, on May 26, 2017, the plaintiffs received notices all dated May 19, 2017, purportedly issued by the Deputy General Manager SASF acting as an author under 13(2) of the Securitization Act, raising a claim on the basis of the financial arrangements described in Schedule 1 hereunder. These notices are not made the subject matter of this suit and no reliefs are claimed. I am clarifying, my lord, I have not challenged the action of the bank taken under the Securitization Act.
That's why I'm asking your prayer D.
Yes,
F. Your prayer F and kindly come. That's why I'm asking. Kindly come to the prayer F. You are asking the mandatory injunction.
So
with
I'll
regard to
the
surface I, and kindly come to the prayer
no, I
C.
won't challenge that. I won't challenge that.
Kindly come to the prayer C.
C, my lord, yes, I will give up that prayer
Acting
so
in
far
terms
as the
of the
injunction is
surface
concerned.
notice.
My lord, C I will give up
Hmm.
because C, my lord, is the second limb of section 34 that lordship might not grant if I apply for an order of injunction.
Correct.
C I might give up later on. F, my lord, the second part I will give up. F, my lord, I will only press for a mandatory decree for mandatory injunction directing the bank to withdraw the notice of 6th of December. I will not, my lord, challenge or I will not initiate any proceeding in aid of the suit challenging the notices issued on the Securitization Act. But that, my lord, I am clarifying. Lordship can record that.
Made amendment. I am granting leave to made amendment. Then come tomorrow.
Very well, I'll.
That you do that. If you.
I'll just strike off the prayers, my lord.
Because you are challenging the surface side.
Yes,
prayer C and prayer F.
Yes.
That you once you are taking into consideration, they have issued the notice, declared the NPA. Subsequently, they have issued the notice for recovery. Now they wanted to possession. That is simply your case.
Yes.
And if again you have come with the notice that they have issued the surface notice, the surface notice is mandatory. It is to be declared as a null and void. So if it is your prayer declaring the surface notice a null and void, so how the
I follow what's following from your lordship. I humbly agree, my lord. What I'll do is that my advocate on lordship will kindly grant leave to my advocate on record. We'll only delete the second limb of the prayer so far as prayer F is concerned. And my lord, I will not press for prayer C. Though, my lord, if I succeed in ultimately getting an order restraining them from not to proceed because they have declared my account illegally as NPA, but the consequential steps will follow.
See, with regard to surface, how the surface start.
Yes.
If you fail to pay, your account has come NPA, then the surface is started.
Yes.
Notice.
Yes, lordship is correct.
Correct. Regarding NPA, there is a
that's under the RBI guidelines. If I do not service the interest in my account for 90 days,
the quantum you have not
yes,
put in the bank, and
then it is declared as an NPA. Post NPA, they start under the Securitization
the
Act.
bank will give an opportunity to clear this.
Yes.
Made the said arrangement in the account to the extent if you're not making this arrangement of the said amount, then the bank will proceed with them.
Yes, lordship is correct, my lord. I bow down.
Suffering for the plaintiff, appearing for the plaintiff. The matter is listed under the heading presentation of plaint. Counsel for the plaintiff prays for making certain amendment in the prayer portion by not pressing the prayer C as well as the second portion of prayer F. Counsel for the plaintiff submit that only in the prayer F, the plaintiff will pray a mandatory injunction against the defendants. Pray for mandatory injunction against the defendant only with respect of the notice dated December 6 December 2023. And the plaintiff will not and will delete the prayer, the second part of the prayer. Delete. Delete / not press the second part of the prayer. In view of the submission made by the counsel for the plaintiff is granted leave to make necessary amendment by deleting the prayer C as well as second part of the prayer F in course of the day, and by putting the advocate on record will make initial after the amendment is carried out. After the full stop, is the matter tomorrow, not Friday.
Friday.
When is the date?
Yes, my lord.
What is the date in the notice?
My lord, the last notice was issued on 8th of October. But that was the urgency.
Friday.
Friday.
My application, initially I did not get an interim order, my lord, on the ground, my lord. They had to explain by your affidavit, my lord, how they are getting the goods, my lord, because these are actually my goods which are interpolated. But prima facie lordship found, my lord, those are not on record. So affidavit had to be filed. No affidavits have been filed. My lord, the matter is part hard before your lord.
Affidavit completed.
No,
My
no,
lord, on behalf of the respondents, I am seek leave to appear virtually, my lord. My lord, as per the last order of my lord, wherein the IA was rejected, my lord, there were directions to serve copy of the application document and copy of plain to the defendant within a week from date. My lord, that has not been served upon us, my lord.
My lord, kindly look at the affidavit of service. This is an incorrect statement from bar, my lord. This is, my lord, kindly look at the affidavit service of, my lord, Mr.
My lord,
Ashutosh.
on instruction, I am communicating, my lord.
Proper
After this order of my lords, we have not received any document, my lord.
No, sir.
This is affidavit of
Though
service.
this court has passed the direction, but on the earlier occasion,
No,
your
affidavit
learned
of
friend
order,
who was appearing, he has appeared and he had all the document, but for the formalities, this court has passed an order for service of
I
notice.
follow. My lord, in case they are relying upon the document which have been served earlier, my lord, we don't have any difficulty to accept that. And
Plain
that is
petition, everything has been
that
served.
is the same thing.
Very well.
They have not filed any supplementary.
No, I have not.
They have not filed any supplementary.
One document, one sub affidavit that I also will have
Yes,
served at
because
the course of
with
hearing.
regard to your the earlier advocate has given some certain documents to the counsel for the plaintiff. The counsel for the plaintiff were dealt with by the supplementary.
My lord, I'm still led by him, my lord. Mr. Amarjeet Singh, I'm still led by him, my lord. And on that basis, my lord, then in that case, my lord may grant me 2 weeks further time, my lord. I'll file my affidavit in opposition.
2 weeks. See, this court has refused the interim order. That's why how soon you can file. Otherwise, I will take without the affidavit. How soon?
My lord, at least 2 weeks, my lord. At least 2 weeks, my lord.
For the plaintiff, so suffering for the defendant through virtual mode. Counsel for the defendant prays for extension of time to file affidavit in opposition. Let affidavit in opposition be filed within 10 days.
Grateful.
Reply, if any, there to be filed within a week thereafter. List the matter on 13th December.
Grateful.
Para 19 of your lordships or the lordship has kept this point open to be decided after affidavit.
That's why you said.
Grateful.
Yes. 5, 6, 7, 9.
Well, time for the plaintiff.
Yes. It will appear on 20.
5, 6, and 29th, my lord. These matters were to appear on the 29th. I believe they inadvertently.
I wrongly appeared. It is appeared on 29th. Yes, deeply applied, sir.
5, 6, 7. Grateful, my lord.
Well, in this matter, I'm appearing for the plaintiff petitioner, my lord.
Yeah.
My lord had granted an interim order, my lord. My lord had directed them to, my lord, the pleadings are complete, my lord. My lord had directed them to maintain the amount of a sum of rupees 44 lakhs and odd, my lord, in the bank account, my lord. My lord, till date, my lord, they had not disclosed anything whether they have maintained the amount in the bank deposit. My lord, on the contrary, my lord, on the last occasion, my lord, they had submitted that they are willing to pay at least the principal amount. On that score, my lord had adjourned the matter on twice, my lord. I'm led by Mr. Kothari.
Yeah.
Lordship, I'm appearing on behalf of the defendant. On the last occasion, I took time as my client was ready to make the payment. And now also he is ready to make the payment, but he is unable to arrange the entire amount till now. So if your lordship will
pay that.
If your lordship will grant kindly any short date as per your lordship.
Friday.
All right, lordship.
Friday, you bring the amount or demand or whatever it may be.
Whatever.
Order for deposit the amount with the
Secure.
registrar.
Your lordship may kindly record this because on the last occasion your lordship was kind enough not to record it
Recorded because it's submitted
on the bona fide of the advocate. But your lordship, since then also they have defaulted. So if your lordship is giving them time till Friday,
Lordship, one last chance. If you as per your
Your Lordship,
lordship.
may kindly record it in your Lordship's
What is the
order.
principal amount?
Your Lordship, my principal amount is 22 lakh 84,740.
Nothing.
And this is an admitted claim, Your Lordship. In their reply to my legal notice, they admit that this is some
Ready to
student.
pay,
Yes, he will be able to pay only the principal amount, lordship. He will not be able to pay the
regard to the
interest.
We'll see to that subsequent.
So let them secure that.
So-and-so appearing for the plaintiff. So-and-so appearing for the defendant. Full stop. Counsel for the defendant submitted. Counsel for the defendant on instruction from her client submits that the defendant is ready to pay the principal amount of rupees
2284,740.
2259. 2259740. Page 6. Paragraph 16.
Lordship,
2259.
I stand corrected. I stand.
2259. 22 lakhs 59,740. Full counsel for the plaintiff submitted. If the matter is fixed on Friday, the defendant will pay the said amount in the meantime. Consider the submission made by the counsel for the defendant. The case is adjourned. Let the matter appear on 29th of November 2024 under the same heading.
Lordship, the interim order may be kindly
Counsel
extended.
for the plaintiff submitted. Interim order granted earlier is going to be expired today and counsel for the plaintiff submit that the interim order granted earlier is going to expire today and paid for extension of interim order. In view of the submission made by the counsel for the plaintiff, interim order is extended till 6th of December 2024 or until further order, whichever is earlier.
Deeply obliged. Deeply obliged.
Lord, I'm appearing for the defendant respondent in this matter.
My lord, pursuant to my lord's order, my lord, they have not filed affidavit, my lord. They had preferred an appeal. By order dated 20th November, my lord, the appeal has been dismissed.
Have you secured the amount?
But I'll just indicate, my lord, I was supposed, my lord, there were twofold compliance which I had to do, my lord. I had to file my reply. Lord, for that, my lord, I'm just praying for a week's time, not more than that, just a week's time. I'll put in my affidavit in opposition. So far as the amount which is to be secured, which your lordships had passed an order, my lord, will also grants me a week's time, my lord. My client is, my lord, procuring funds so that the amount can be put into a separate account. I will provide the details to the petitioner. And my lord, I'll also state, my lord, the compliance in my affidavit in opposition. Will kindly gives me just a week's time, my lord.
Yes, then
Just a week's time, my lord, I was humbly praying, my lord. And your lordships may post this application for hearing on any time.
but if you file the affidavit, then they will find the reply. How soon you will file the
Compliance, my lord, he is saying he'll secure the money in a week's time, my lord.
In a
Kindly
week?
In a
record.
week's time, yes, my lord.
And how soon you file the affidavit?
My lord, within 7 days, my lord. Within a week.
Appearing for the plaintiff. Appearing for the defendant. Counsel for the plaintiff has handed over the order passed by the appellate court dated 20 November 2024, wherein the appeal preferred by the defendant is dismissed. Let the order dated 20 November 2024 be kept with the record. 20 November 20 be kept with the record. Counsel for the plaintiff submit that the defendant has not complied with the order passed by this court by securing the amount of rupees 40 lakhs 07,102 in a separate account. Counsel for the defendant assured before this court, if a week time is granted, the defendant will file affidavit in opposition and will also secure the amount of rupees 40,07,102 in a separate account. In view of the undertaking given by the learned counsel for the defendant, time to file affidavit in opposition is extended for a period of 1 week. And in the meantime, the defendant is also directed to secure the amount of rupees 40,07,102 in a separate account and to disclose the details of the same in the affidavit in opposition. Full stop. After serving the copy to the learned counsel for the plaintiff, the plaintiff is directed to file affidavit in reply within a week thereafter. Full stop. Please the matter on 16th December 2024 under the same heading. Deeply obliged.
I'm appearing for the plaintiff in this matter. Lord, my GA application, my lord, a new application is on board today, my lord.
GA1?
GA1.
What is the application
Lord, this
for?
is an application, my lord, for the reimposition of the interim order which your lordships had granted on 9th of August. But I had satisfied your lordship that I have a prima facie case where the amount, Lord, it's a suit for recovery of money. Lord, I had paid advance of rupees 10 lakhs. My lord, pursuant to which, my lord, there was an understanding that the defendants will receive the advance and will supply me goods, my lord, within a specified timeline, that is within 4 to 6 weeks from the date of issuance of the purchase order. My lord, the defendant, my lord, admittedly, my lord, failed to do so. My lord, thereafter, my lord, I write repeated letters, no response. On 2 occasions, at least on twice, my lord, the defendants admitted that there is a, my lord, admittedly a delay on their part to supply the goods, my lord. Thereafter, my lord, I had moved the application, my lord, praying that to the extent of 10 crores, my lord, my interest be secured, the subject matter of the suit be secured. Lordship passed an interim order on 9th of August. It expired on, my lord, 12th of September. My lord, we could not, my lord,
For extension.
but we did not apply for extension, my lord, within the period of
Complied with the order 39.
Lord, insofar as, my lord,
Serve the copy.
serve the copy, that is also recorded in the order, my lord, the last order, my lord, where we had filed the affidavit of service, and in despite of service, my lord, the defendant chose not to appear. Lord, now that we have a new application on board, my lord, I was humbly praying, my lord, if your lordship kindly takes the prayers in my application. In fact, the order dated 4th of October would reflect that the defendants were served. The defendant was served.
So you have read all the prayer in the application. This is GA1. This is with regard to the interim order. Where is the imposition? Any application is filed reimposition? Have you filed any application?
Yes, my lord, I have,
imposition of the...
yes, my lord, I have filed an application.
Where is that? Which application? What is the application number?
Number bolo. But possibly, my lord, it should be GA2 because,
GA2 है
my
क्या?
lord,
GA2 आया?
but actually, my lord, my advocate on record today is not here. My lord, that's the difficulty. Otherwise, I would have pointed out, my
One
lord.
thing, you confirm from the department because GA2 is not on record. If it is, I am fixing not today only. It will come on Friday.
Very well. In the meantime, we'll get it listed. I'm deeply obliged.
Counsel for the concessions offering for the plaintiff. None appears on behalf of the defendant. Counsel for the plaintiff submitted. Plaintiff has filed an application being GA Form 2 of 2024, praying for reimposition of the interim order passed by this court dated
9th of August, 2024.
9th August 2024. But the said GA is not placed on record. In counsel for the plaintiff is for fixing the matter on 29th of November 2024. Let the matter appear on 29th of November 2024. Police. So the department is directed to place the record of GA2 of 2024 along with CS 716 of 20, CS COM 176 of 716 of 2024 on the next date fix. Yes, come on.
I'm deeply
My lord, I am appearing for the plaintiff respondent in this matter.
Yes.
My lord, on the last occasion, parties were directed to file their affidavits. But the difficulty is that by order dated 14th November, my lord, the plaintiff has been admitted into CIRP.
So what can be done? You are for
My
the
lord,
plaintiff.
my lord.
So
My lord, we are taking steps to challenge that order and praying that the matter be kept either in the month of January or February.
I am appealing for the defendant number 4. I had filed, my lord, we had filed a recalling application to my lordship's order dated 21st August 2023.
What is the order?
My,
Interim order?
yes, my lord, my seniors, my lord, in this matter, my lord, I am led by Miss Anna Malhotra. Due to personal difficulty, she is not in court today, my lord. I had not this week only, my lord.
I'm appearing for HDFC Bank Limited, my lord, one of the respondents, my lord. My lord, the copy of this application has not yet been served upon us, my lord.
Recalling application.
Now he is in trouble. You are for the HDFC, defendant number 3.
I am appearing for the defendant number 4, my lord.
You are for the 3.
I am for HDFC Bank Limited.
3. You are for the Indus Bank.
I am IndusInd Bank.
কি বলছে? So appearing for the plaintiff. So appearing for the defendant number 3, HDFC Bank. And so appearing for the defendant number 4, IndusInd Bank Limited. Police. Counsel for the defendant number 3 submit that they have not received the copy of the application being GA.com 5 of 2024. Not 5. Which application?
GA5 of 2024, my lord.
You filed?
Yes, my lord.
No. What is your GA?
My lord, I am for the plaintiff. I have not filed any application.
GA5 of 2024 filed by the defendant number 5 and 4. Sorry. Defendant number 4. The counsel for the defendant number 4 is directed to serve the copy of the application to the defendant number 3 within a week from date. Counsel for the plaintiff submit that the plaintiff has gone in the CIRP and the plaintiff has already prepared an appeal against the said order.
My lord.
And prayed for some time. In view of the submission made by the counsel for the plaintiff, the case adjourned. Let the matter appear on 17th December 2020. Next.
My lord, item 12, my lord. I'm appearing, my lord, for the petitioner defendant. This is, my lord, my application for extension of time to file written statement. My lord, it is within 120 days. Writ of summons served on 10th of September 2024, my lord. And the 30 days period, my lord, expired within the period of vacation on 10th of October 2024. My lord, the written statement, after the application has been filed, my lord, the written statement has been affirmed. It's affirmed 19th of November 2024. We can file it even today itself, if need be.
Yes, who is appearing for the plaintiff?
It is, my lord, within it is within the, my lord, 120 days period, my lord. So
yes, madam.
My lord, my senior Mr. Rudujit Sarkar is appearing in this matter for the petitioner, my lord. He's under the weather today, so my lord may please... Under the weather, my lord. He's not well.
So?
If my lord may please place this matter any day next week.
It's an extension of time. You have any objection? Have you taken instruction from your senior? It is within 120 days, after 30 days. What is your objection? When your senior will be available?
My lord, any day next week.
Let come her senior.
that's your lordship, please.
Sons appearing for the plaintiff, sons appearing for the defendant. Full stop. Counsel and the plaintiff and the defendant has filed an application being GA.com 1 of 2024, praying for extension of time to file written statement. Full stop. Counsel for the plaintiff submit that the learned senior appearing on behalf of the plaintiff is not well and prayed for adjournment. Is not well and prayed for adjournment. In view of the submission made by the counsel for the plaintiff, the case adjourned. Let the matter appear on 3rd December. Come on, 3rd
Grateful,
December.
Grateful, my lord. Deeply.
Yes.
My lord, my client had filed the Section 8 application. My lord, Section 8, when a Section 8 application is filed within the time and as per Section 8 of the Act, this suit is not to be proceeded with. My lord, the only exceptions are, my lord, if some dispute falls beyond the scope of the agreement.
Before Mr. Gupta starts, I was told, I did not cite the judgments on jurisdiction. Is Mr. Gupta is pressing the point on jurisdiction?
Yes. That was my submission.
So on territorial jurisdiction, my lord, but on territorial jurisdiction, I want to cite one judgment, and this is that. Kindly see the forum selection clause.
Which one?
In the agreement, there's a forum selection clause which they are relying upon. But she kindly comes to the Section 8 application GA2. Page 60.
Yes.
This clause 11. The courts, forum selection clause are not to be too widely interpreted. The courts at the place of ownership of rakes by the respective sale plant shall have exclusive jurisdiction over any dispute arising out of or in respect of this contract, that is supply of bogie open wagon time. As you kindly notes the word, it's very carefully worded. It is intentionally the parties did not use the word that the courts at the plant at so and so will have jurisdiction.
Sale plant only shall have the
court at the place of ownership of rakes.
Correct.
Now, this is the plaintiff case, not contradicted, and can't be, that no rakes were supplied, could not be supplied. So, ownership, so the rakes I shall be making, I shall be transferring to them. Only then there's a question of ownership of rakes, ownership of rakes by the respective sale plant.
No. Till date, you will not sell the rakes to the defendant. So you are the owner.
I am in Calcutta. Sale plant, logically sees the word by the respective sale plant only. I am not sale plant. So either this clause does not apply to this case.
Okay. Ownership of the rakes by the respective sale plant.
Sale plant
shall only have the exclusive jurisdiction over the dispute arising out of the respective contract. Yes.
So I am, if assuming I have prepared the rakes but lying in my factory, that's nobody's case also. Had that been the case also.
Yes.
That's so. This is apart from my other point, which also applies in case of the forum selection clause. My principal cause of action is their non-implementation of the circular, the office memorandum of the government, which is binding on them, which has nothing to do with the contract, that is the statute. So dispute arising as to enforceability of the office memorandum is not a, but even otherwise, it is not even the Section 8, the jurisdiction application case, that the rakes have been that we have supplied the rakes ownership. So this clause doesn't apply at all. And so far as the defendant's office is concerned, Lordship kindly takes a look at the cause title, the defendant number 2, having its Eastern Regional Office at Ispat Bhavan.
Within jurisdiction.
Within jurisdiction. My lord, assuming for the sake of, since I don't have to go into this part of the factual part, assuming no part of the cause of action arose assuming no part of the cause of action arose at in original site jurisdiction. Of course, it is covered by Eastern Regional Office. This is, but assuming for the sake of argument that no part of the cause of action arose within the original site, since the defendant has an office within the original site, and unlike the and the Chartered High Court doesn't, for Chartered High Court clause 12, it does not have to be the registered office or the office where the cause of action arises, which is the case for section 20 suits. Actually, just for the sake of formality, I will show one judgment. That is the 1514 SCC. No, sorry, no. Sorry. 157 SCC. Oh, Girish Gupta, yes. May I not 57 SCC? This is a Calcutta High Court Division Bench. 2002, Volume 1, Calcutta Law Journal, page 366.
Yes.
Lordship kindly comes to paragraph 2, where the issue arose, just mere office where no cause of action arises, paragraph 2. The suit is a suit for recovery of damages against sale, which carries on business within the ordinary original civil jurisdiction of the court. It is on this basis that the jurisdiction of this court has been invoked. Mr. Chatterjee, learned advocate appearing in support of the appeal, has contended that the office of the defendant situate within the jurisdiction has never dealt with nor had any occasion to deal with any part or portion of the transaction. I'm just stopping here so far as paragraph 2 is concerned. So this was the issue. Lordship kindly comes to paragraph 5.
Yes.
This submission of Mr. Chatterjee cannot be accepted for the reason that under Section 120 of the CPC, provisions contained in 16, 17, and 20 of the Civil Procedure Code do not apply to this court in the exercise of its ordinary original civil jurisdiction. Institution of a suit in this court is governed by clause 12 of the legislation, which provides as follows. As we do further ordain that the said High Court of Judicature at Port William, in the exercise of its ordinary original civil jurisdiction, shall be empowered to receive, try, and determine suits of land or property
such land or property shall be situated.
Oh,
land or property.
Sorry, in the court of suits for land or other immovable property, if in the case of suits for land or other immovable property, where such land shall be, I think there's a typographical error, shall be situated, but we are not concerned with this part. Or in all other cases, if the cause of action shall have arisen either wholly or in part.
That is the problem. If the cause of action arose only
Next
in
part.
the
Or in case leave of the court shall have been first obtained in part within the local limits of the ordinaries. Or, now I am on the last or fourth line. Or if the defendant at the time of the commencement of the suit shall dwell or carry on business or personally work for gain within such limits, except that the said High Court shall not have jurisdiction in case of falling on the small causes court. I am on the last or. If the defendant at the time of the commencement of the suit shall dwell or carry on. This is what has been interpreted in this judgment.
If the defendant at the time of commencement of the suit shall dwell or carry on business or personally work for gain. Yes.
Now, Lordship kindly comes, paragraph 6 and 7, construing clause 12 of the letter stated, it has been held in Mutras Electric Supply 89 C50 that there are cases of absolute jurisdiction which the court can neither assume nor can the court renounce. The case of absolute jurisdiction are discussed in the following paragraph. A close scrutiny of this clause therefore reveals that there are certain total and absolute jurisdiction of this court. They are where the whole of the land or immovable property is situated within its jurisdiction when the suit is for land or immovable property. It is also the case where the whole of the cause of action arises within the jurisdiction of this court. Also, that is the case where the defendant at the time of the institution of the suit dwells or carries on business or personally works for gain within the jurisdiction of this court, irrespective of the fact where the cause of action arises. So I don't have to ask for clause 12 leave also. These three are the categories of total and absolute jurisdiction of the court under the grant of power in clause 12 of the latest patent. No question of the litigant having to take the leave of the court arises in these three cases, so long as the litigant satisfies the test laid down in these three cases. His right to institute the suit in this court is absolute and unfettered. The court can neither assume nor renounce such jurisdiction. If the plaintiff can show that the defendant carries on business within jurisdiction of this court, then where did the cause of action arise is wholly besides the point. In this case, but the judgment which we rely upon most is the abdomen case. This is Sujata Manohar's judgment. 99-2 SCC 446 may be referred to where their lordships were concerned with clause of the legislation of the Bombay High Court, which is the same as that of this court. An identical question was raised in that case, which their lordships negative on the ground that the defendant was carrying on business within the jurisdiction of the Bombay High Court. The relevant portion of the judgment, I will just place this quotation, then I shall stop. However, under section 120 of the CPC, section 16, 17, and 20 of the Civil Procedure Code do not apply to a High Court in the exercise of its original civil jurisdiction. Possibly they've copied 1890 Dublin's wordings. Jurisdiction of the Bombay High Court to entertain a suit under its ordinary original civil jurisdiction is determined by clause 12 of the latest patent of the Bombay High Court. Under clause 12 of the latest patent, a place where the defendant or each of the defendants, where there are more than one at the commencement of the suit, carry on business, would be a place where the court would have jurisdiction. Therefore, under clause 12 of the latest patent of the Bombay High Court would have jurisdiction over the subject matter of the dispute in the present case.
Yes.
Well, so far as jurisdiction is concerned, Lordship, this is my most humble answer. Great. Very good.
Yes.
As I was submitting, when a Section 8 application is filed at appropriate time as per Section 8, then a suit will not be proceeded with. Well, the only exceptions carved out are that if the dispute falls beyond the scope of the agreement, or where the issue may be in public domain. My learned friend's case is that in his case it falls within that public domain aspect. Why? Because he says that the reduction in the enhancement in the rate of GST,
correct,
that is a part of that's a legal aspect, and which should be left to be decided by the court,
not by the arbitrator.
Not by the arbitrator. The other thing he had pointed out is regarding the government circular which reduces the PBG amount from 5 or 10% to 3%. These, he says, are matters of coming within public domain, and therefore, the suit will be maintained. I humbly submit this. If your lordship kindly takes up section 28.
Arbitration.
Section 28, clause A. Rules applicable to substance of dispute. Where the place of arbitration is situated in India, A. In an arbitration where other than an international commercial arbitration, the arbitral tribunal shall decide the dispute submitted to arbitration in accordance with the substantive law for the time being in force in India. Therefore, the arbitrator has to take into consideration what is the substantive law prevailing in India. If the substantive law, the GST is a matter of substantive law, therefore, it's not that there's something, the virus of it or things like that are being challenged. The question is, my lord, why the seal authority has not reduced it? I mean, has not increased it. GST. Therefore, this is falling within the scope of a substantive law in the country. Therefore, the arbitrator definitely has the jurisdiction. In fact, he has to decide it as per the mandate after 2018. Now, kindly take subsection 3 of this section. While deciding and making an award, an arbitral tribunal shall, in all cases, take into account the terms of the contract and trade usages applicable to the transaction. The terms of the contract and trade usages applicable to the transaction. Trade usage, my lord, is covered by the government circular, the notification, which, my lord, reduces this PBG. Yes. My lord, I cite, my lord, a few judgments on this. 22. My lord, first is 2022, volume 2. Let's have it copy. Our SCC online here, so. May 22. Oh. This is 2022, volume 2, Supreme Court cases, page 275. I first take your lordship to paragraph 14 to 17. Yes. The law on paragraph 14, the law on interference in matters of awards under 1996 Act has been circumscribed with the object of minimizing interference by court in arbitration matters. One of the grounds on which an award may be set aside is patent illegality. What would constitute patent illegality has been elaborated in Associated Builders, where patent illegality that broadly falls under the head of public policy has been divided into 3 subheads in the following words. In the 1996 Act, this principle is substituted by the patent illegality principle, which in turn contains 3 subheads. 42.1, a contravention of the substantive law in India would result in the death knell of an arbitral award. This must be understood in the sense that such illegality must go to the root of the matter and it cannot be of a trivial nature. This again is really a contravention of section 28(1)(a) of the Act, which reads as under. Then I've already placed that. Yes. Then 42.2, a contravention of the Arbitration Act itself would be regarded as a patent illegality. For example, if an arbitrator gives no reason for an award in contravention of section 51, such award will be liable to say. Then 42.3. Equally, the third subhead of patent illegality is really a contravention of section 28(3) of the Arbitration Act, which reads as under. This is not the in all cases, arbiter shall decide in accordance with the terms of the contract and shall take into account usages of the trade. The last contravention must be understood with a caveat. An arbitral tribunal must decide in accordance with the terms of the contract, but if an arbitrator construes a term of the contract in a reasonable manner, it will not mean that the award can be set aside on this ground. Construction of the terms of a contract is primarily for an arbitrator to decide, unless the arbitrator construes the contract in such a way that it could be said to be something that no fair-minded or reasonable person could do. Then paragraph 15. In Sangyong Engineering versus Construction, speaking for the bench, Justice R.F. Nariman has spelled out the contours of the limited scope of judicial interference in reviewing the arbitral awards under the 96 Act, and observed thus. What is clear, therefore, is that the expression public policy of India, whether contained in section 34 or section 48, would now mean
the fundamental policy of Indian law as explained in para 18 and 27 of the Associate Builders. That is, the fundamental policy of Indian law would be relegated to Renu Sagar understanding of this expression. This would necessarily mean that Western Gecko expansion has been done away with. In short, Western Gecko, as explained in paragraph 28 and 29 of Associate Builders, would no longer obtain, as under the guise of interfering with an award on the ground that the arbitrator has not adopted a judicial approach. The court's intervention would be on the merits of the award, which cannot be permitted post-amendment. However, insofar as the principle of natural justice is concerned, as contained in section 18 and 32 of the Act, these continues to be the ground of challenge. It is important to notice that the ground for interference insofar as it concerns the interest of India has since been deleted and therefore no longer obtains. Equally, the ground for interference on the basis that the award is in conflict with the justice or morality is now to be understood as a conflict with the most basic notions of morality or justice. This again would be in line with paragraph 37. It is only on arbitral awards that shock the conscience of the court can be set aside on the ground. Now, paragraph 17. Having regard to the aforesaid parameters, we may proceed to examine the facts of the instant case. As noted above, this court is required to examine the singular issue as to whether any interference is called for in the award on the ground taken by the appellant state that the learned arbitrator, as also the High Court, has ignored the binding terms of the contract governing the parties relating to recovery of supervision charges from the respondent company, and the circular dated 27/7/1987 issued by the state government on the same lines, which, as per the appellate state, goes to the root of the matter. Here also there is a circular, but this is all mere post-award situation. The judgment is linked. Then kindly come to paragraph 20. Paragraph 20 at page 286. The circular dated 27/7/87 issued by the government of Madhya Pradesh provides for the assessment of the actual collection expenditure of the shal seeds supplied from the year 1981 to 1986 and stipulates such and such. Then paragraph 23. On a conspectus of the facts of the case, it remains undisputed that though the appellant state did raise an objection before the arbitral tribunal on the claim of the respondent company, seeking reduction of supervision charges for which it relied on clause 6b of the agreement, and the circular dated 27/7/87 to assert that recovery of supervision charges along with expenses was a part and parcel of the contract executed with the respondent company. The said objection was turned down by the learned sole arbitrator by giving a complete go-by to the terms and conditions of the agreement governing the parties and observing that there is no basis to admit any such indirect expenses. The circular dated 27/7/87 issued by the government of Madhya Pradesh that provides for imposition of 10% supervision charges on the amounts calculated towards the cost of shal seeds in the expenditure incurred was also ignored. Pertinently, the respondent company has not denied the fact that supervision charges were being levied by the appellant state and being paid by it without any demur as a part of the advance payment made on an annual basis. Right from the date of the parties had entered into the first agreement, that is 38/79. This fact is also borne out from the specimen copies of the orders filed by the appellant state with the appeal that amply demonstrate that the cost of shal seeds required to be paid by the respondent company included supervision charges described as such and such in the vernacular language. It was only after the appellant state had terminated the second contract on 21/12/98 that the respondent company raised a dispute and for the first time claimed refund of the excess amount purportedly paid by it to the appellant towards supervision charges incurred for supply of shal seeds. In our opinion, this is a patent illegality and is manifest on the face of the arbitral award. Here, the arbitrator failed to take into consideration the circular. The circular. Now, that situation has not arrived in our case. This is post-award situation. That situation is not present in our case. There can be no presumption that the arbitrator shall not take into consideration this circular issue. Yes. Now, I will cite another judgment where a subsequent amendment
in the legislation itself was considered by the tribunal, and the court did not interfere after the award was passed. Why did the court do this? Well, this is 2015, volume 14. volume 14, Supreme Court cases, page 21. কি দিলাম আপনি? 2015 volume 14 Supreme Court cases, page 21. আরেকটা দেখো, page 21. Page 21. কি দিয়েছে? No, my lord, let me find it out. In the meantime, this is not the judgment I was referring.
This is a Sundaram Finance.
Yes. My lord, I shall place it after some time. But before that, your lordship, kindly take this 2020 কোথায়? 2020 volume to CLJ.
এটা বই আছে,
এটা ফেরত দেবো।
সেটা বই আছে।
2020 volume 2 CLJ, page 71. Volume 2020 volume 2 CLJ.
Page 21.
Page 71.
এটা page 21 তো?
আরেকটা দেখো, তোমার কাছে থাকবে। আর এটাও দেখাবো, এটাও তো দেখাবো। হ্যাঁ, এটা আছে তো, এদিক ওদিক হয়ে গেছে। দেখো দেখো। This is 2020 volume 2. Kindly take me out paragraph 22. This is a division bench judgment of our High Court. It says, my lord, that in the context of section 28A and 1A and 3, dispute in relation to legal matters are also to be decided. My lord, take paragraph 22, clause 4 of the agreement at page 79. Paragraph 22.
Yes.
Clause 4 of the agreement is not under challenge. The parties have until the filing of the writ petition proceeded on the basis of the said agreement. The predecessor in interest of the petitioner respondent, Messrs. Larsen and Tubro, had also applied to this court for appointment of an arbitrator on similar disputes in the past, prior to the circular dated 10th February 2005. The agreement with the writ petitioners contains similar clause and pertains to the same go downs. The demand for enhanced license fees in the earlier dispute was on the basis of clause 4 of the agreement, as the circular dated 10th February 2005 had not yet been modified at that time, and that the dispute arose out of the agreement between the parties is beyond the pale of any dispute. The writ petitioners have not argued that the present dispute is not covered by the arbitration clause. A suit filed by the writ petition would be barred under Section 5 of the Arbitration Conciliation Act 1996 and would be the subject of an application under Section 8 of the Arbitration Act 96. When the parties with their eyes wide open have entered into an agreement and had agreed that in the event of a dispute arising out of the said agreement, such dispute shall be resolved by arbitration, the parties are bound by the arbitration clause unless the agreement is vitiated or withdrawn. The parties have in the past for earlier periods on similar issues had earlier taken recourse to similar arbitration clause for the adjudication of the disputes, and accordingly at this stage the writ petition cannot turn down and seek a redressal in a writ petition. It is important to mention that for the earlier periods, arbitration proceedings are pending between the parties concerning similar dispute, and the predecessor in interest of the writ petitions applied to the court under Section 11.
Well, my learned friend had cited 2022 SCC online. 2022 SCC online 4447. 4477. This is Chairman Board of Trustees Shama Prasad versus Universal Seaport.
Yes. Calcutta 4. Yes.
Yes, Calcutta 4. Shama Prasad Mukti. The judgment justice Sharaf had delivered paragraph 28 was placed. Paragraph 28, in my understanding, the respondents seem to have found favor with arbitrator's sympathies, but unfortunately, they do not find favor with my sympathies, and most unfortunately, they do not find favor with the law. It is evident that considerations of discrimination and want of state functionaries to act in due conformance to Article 14 of the Constitution swayed the arbitrator's contractual interpretation. The aforesaid inference can be gauged from the paragraph 5e of this judgment. Firstly, arbitrators cannot apply the rights envisaged under the fundamental rights of the Constitution of India or equity while granting arbitral awards, and if they do, such awards must be set aside as being patently illegal under Section 34(2)(a) of the Act. The arbitrator is a creature of contract and must act within the powers granted by it. In the Board of Control for Cricket, etc., the Bombay High Court, while dealing with the arbitrator's power to invoke Article 14 of the Constitution, held that. Then, Milord, it is quoted. Milord, two different considerations, Milord, this is a BCCI judgment. Do different considerations arise when one of the parties is the state within the meaning of Article 12. Here, the learned sole arbitrator held that BCCI is not the state, but held that it nonetheless performs public function. Would that make a difference in arbitration? Are dispute resolution constrained by private law? It would appear not. Certainly, the public law duty to act fairly cannot be imported into a contract by a private law arbitral tribunal to effectively alter its terms so as to create an obligation on the so-called public duty party that the contract does not envisage. Assistant Excise Commissioner versus Isaac Peters. This is true even of a statutory contract. In Isaac Peters, Supreme Court held that in case of contracts freely entered into with the state, there is no room to invoke the public law doctrines of fairness and reasonableness to alter or add to the terms of the contract that is cast on the state, a contractual burden that the contract itself does not contemplate. A division bench of the Delhi High Court went so far as to say that there is no scope for applying the doctrine of arbitrariness in a private law field. That remedy is a public law remedy. Its avenue is different. A division bench of this very court took the same view in ONGC. It had no hesitation in setting aside the order under appeal, which held that a particular clause was unconscionable and against public policy. Another division bench of the Delhi High Court also took a similar view. There can be no answer at all to Mr. Mehta's submission. There is no quarrel that the proposition that a court, especially constitutional court, is not constrained in the same way as an arbitrator. Public law actions demand public law remedies. The suggestion is not that the public authority can play Jekyll and Hyde, or that it is required to demonstrate fairness only in public law action. The question is, what is it that the decision-making body is empowered in law to do? A writ court may well hold that against a public body on a public law principle or by invoking Article 14. But an arbitrator constrained as he is or she is by the contract has no such power. A careful reading of the relevant authorities.
This is the main, but an arbitrator constrained as he or she is by a contract has no such power.
Yes. Now, here the question before your lordship is GST revision, PBG rate revision. Remember, these are
As per law. The first one is as per law. The second one is as per government trade circular, trade usage. 28(1)(a) and 28(3). This casts an obligation on the arbitrator to take into consideration these aspects, the law and the trade usage. The arbitrator is not going into the question of the arbitrariness or unreasonableness of any term of the contract. That is not required to do, whether it falls within the domain of public law. Therefore, the particular clause is bad. This the arbitrator cannot say. But then, in respect of the matters raised here before your lordship, the questions raised here, this is a matter which only needs a look to the particular provision in law and particular circular, nothing else. And the arbitrator has to decide following that. Now, if he does not do so, if he goes beyond that, then and in the award, there may be a ground. To challenge that. That is different. That's a different situation. But here the question is whether arbitrator can look into this law or not. These 28 and 3 years.
So you mean to say if any circular or any rule issued by the government after the agreement, so arbitrator and it is connected with the agreement, so arbitrator has the power to look into.
Not only he has the duty to look.
Okay, that's why
he has the duty to look.
Yes.
Mirror 1991 volume 1. তোমার কাছে কি করবে লিস্টটা নেই তুমি আমাকে বললে তুমি খুঁজছো তখন 1991 1 SCC
Indian Oil Corporation?
Yes. Huh. Obul has cited it. কোথায় আমার এখানে আমি তো জজ সাহেবকে কি দেবো 1991 1 my learned friend had cited 1991 1 Supreme Court cases 533 533 if your lordship kindly takes that. My lord, paragraph 11 was referred to.
Yes.
We may at the outset mention that it is not necessary in the present case to go into the constitutional limitations of Article 14 of the Constitution, to which the appellant corporation as an instrumentality of the state would be subject, particularly in view of the recent decision of this court in Barkadas, Marfatia, etc. And this is on account of the fact that the suit was based only on breach of contract and remedies flowing therefrom, and it is on this basis alone that the arbitrator has given his award. Sri Salve is therefore right in contending that the further questions of public law based on Article 14 of the Constitution do not arise for decision in the present case, and the matter must be decided strictly in the realm of private law rights governed by the general law relating to contracts with reference to the provisions of the Specific Relief Act, providing for non-enforceability of certain types of contract. It is therefore in this background that we proceed to consider and decide the contentions raised before us. Therefore, if the constitutional question does not arise at all, which I say in the present case, that issue is not relevant at all. Only apply the law, only apply the circular. The arbitrator has to do that. If he doesn't do it, the award will be bad. That will be a ground for challenge on the ground of patent illegality, but not his jurisdiction to decide this dispute is not taken away by any of this.
Yes.
এই 2015-2014-21
না না
যেটা তখন দেখাতে যাচ্ছিলেন
15-14-21
হ্যাঁ এই যে মার্ক করা আছে আর এটা আপনার ওটাতে আপনার ফ্ল্যাগ করা আছে এটা আপনার
paragraph 26
paragraph 26
okay.
Page 40.
Milord, I was going to cite one judgment which I couldn't do, Milord, because the copy was not with me. This is, Milord, in 2015.
2015?
2015, 14 SCC. 2015, 14 SCC.
Yes.
It has been flag marked. Page 21. Milord, I will read paragraphs 24, 26 and 27.
24?
26 and 27. Where 24 is only for the purpose of showing to Lordship the sections 20, the 28 and 29, section 20, 1A and 3.
Yes.
This is quoted in section in paragraph 24. Finally, come to 26 and 27. We now turn to the reasoning given by the arbitral tribunal in paras 21 to 23 of the award as quoted above. The award considers the impact of clauses 70.1 and 70.2 and agrees with the contention that the provision for cost escalation based on the agreed price adjustment formula falls in one compartment, while the compensation for additional cost resulting from a subsequent legislation falls in a separate category. In other words, contention that stands accepted was that the escalation in price premised on fluctuation in market value of the input stands on one footing, while the additional cost resulting from the impact of any statute, decree, ordinance, law, etc., as referred to in clause 70.8 stands on the other. Resultantly, the governing clause in the instant case were held not to be subject to clause 70.1 to 70.7, but the substantive part of clause 7.8. Then, Milord, the rest I am omitting. Paragraph kindly come to 27. In the backdrop of the law laid down by this court, the construction of the terms of the contract by the arbitral tribunal is completely consistent with the principles law laid down by this court. Upon construing the terms and material on record, it concluded that the instant matter would be covered by substantive part of clause 70.8 of COPA. It also noted that NHAI itself was of such opinion. The view so taken by the arbitral tribunal after considering the material on record and the terms of the contract is certainly a possible view, to say the least. We do not see any reason to interfere in the division in our considered view was completely right and justified in dismissing the challenge. Milord, kindly come back to paragraph 26. Here the arbitrator had taken into consideration subsequent legislation. He divides in two categories. One is price adjustment formula.
Correct.
And contract, and the other is additional cost resulting from subsequent legislation. That is also taken into account. And the court says the arbitrator
Subsequent legislation has been taken into consideration. In the separate
and the court says the award is right. And for that, my reliance is placed on 28.1A, section 28.1. Milord, the
yes,
that's the original Sina. Mirror the judgment in the case of Good Earth Minmet of delivered by Justice original Sina of our court that was cited before your lordship.
Yes.
Mirror here the court found that the out of two claims, the suit had two different claims, one of which was forming part of the agreement, the other was not. And on that very premise, Milord, the judgment was passed. Come to paragraph 19, page 19, the fifth line from top.
Yes.
This court thus has before it two separate claims made by plaintiff in which one includes part of it for total failure of consideration on allegation that it relates to breach by defendant to transfer the mine, and at least acknowledgement of defendant that disputes are in parts for entirety of them to be referred. Section 8 had its unamended provision substituted by amendment made and given retrospective effect from 23rd October 2015. Between unamended provision and substituted provision by amendment, there is no change in the section to the extent a judicial authority before which an action is brought in a matter which is the subject matter of an agreement shall. Court finds subject matter of suit cannot be said to be subject matter of arbitration agreement between the parties. The arbitration agreement is contained in the agreement dated 22nd May 2008. Neither party has asserted arbitration agreement in oral agreement pleaded in paragraph 4 of the plaint. Defendant's assertion that the entire dispute be referred to arbitration as arising out of agreement dated 22nd May 2021. Court is unable to accept the reason on a specific finding that a part of the claim in the suit falls beyond the agreement.
That's why here in this case, with regard to the agreement, now the question whether the memorandum which they are claiming, whether that can be taken into consideration.
Memorandum means the government.
Yes.
You are reducing.
Correct.
The PBT
Reducing
from 5 to 10 to
3%.
3%.
3%.
That is a trade usage.
That's why. Now you're telling that it is coming under the purview of 28A and 3.
Because this is applicable across the board.
And they are telling them, no, this is a public domain, it cannot be, arbitrator cannot.
The question is, does it require a constitutional court to decide this?
Correct. Once it has been
What
given.
is this? It
is a benefit.
Yes. One must straightway apply it. Now, why the question may be asked why the steel authority did not react to their prayers that reduce this or increase that, etc. They were not doing anything, not performing any part of the contract for years. The supply of 41 wagons are to be made within a year. 4 years gone by, they did not supply even one wagon. Why should I enter into negotiation or correspondence with them?
Okay.
The other judgment referred to as 2004 SCC online by my Lord and friend. Calcutta 377.
Yes.
Judgment delivered by Justice Kamal Mukherjee. Paragraphs 12, 13, and 14 were referred to. Pecho? Paragraphs 12, 13, and 14. Has your lordship got it?
Yes, yes.
Paragraph 12, I am placing. Supreme Court of India in P. Anand Gajapati Raju reported in such and so laid down the following conditions which are required to be satisfied under subsections 1 and 2 of section 8 of the Act of 1996 before the judicial authority can refer the parties to arbitration. There is an arbitration agreement. A party to the agreement brings an action in the court against the other party. 3. Subject matter of the arbitration is the same as the subject matter of the arbitration agreement. And 4. The other party moves the court for referring the parties to arbitration before it submits his first statement on the substance of the dispute. In the said decision, it was further held that the language of section 8 of the State Act of 96 was peremptory, and it was therefore obligatory for the court to refer the parties to the arbitration in terms of that arbitration agreement. Nothing remains to be decided in the original action or the appeal arising therefrom. Then 14. Supreme Court of India in CourtNo Holdings 2003 volume 5 held that the said Act of 1996 did not oust the jurisdiction of civil court to decide the dispute in a case where parties to the arbitration agreement did not take appropriate steps as contemplated under subsections 1 and 2 of section 8 of the Act of 96. There was no provision in the said Act of 1996 that when the subject matter of the suit included subject matter of arbitration agreement as well as other disputes, the matter was required to be referred to. Kindly note this part. There was also no provision for splitting the cause or the parties and referring the subject matter of the suit to arbitration. There was no provision as to what was required to be done in a case where some parties to the suit were not parties to the arbitration agreement. It has been held that the subject matter of the suit ought not to be bifurcated. Any bifurcation of the subject matter of the suit, one to be decided by the arbitral tribunal and the other to be decided by the court or judicial authority, would lead to anomalous results. The Supreme Court of India noticed that this would inevitably lead to delay and increase in the cost, etc. Now, kindly read, my lord, in this context, paragraphs 18 and 19. Mr. Banerjee relies upon the decision of the Supreme Court of India in Hindustan Petroleum and submits that when there is an objection before the civil court as to the applicability of the arbitration clause to the facts of the case, the same will have to be raised before the arbitral tribunal under section 16 of the said Act of 1996, and the civil court cannot proceed to examine the applicability of the arbitration agreement to the facts of the case. Mr. Abhijit Mitra, learned advocate, appearing on the plaintiff, submits on the contrary that in the said decision, Supreme Court of India did not consider the earlier decision in CourtNo. The decision in Hindustan Petroleum has no application. In that case, the existence of the arbitration clause was admitted and there was no third party involved. The Supreme Court of India therefore observed that if there was any objection as to the applicability of the arbitration clause to the facts of the case, the same would have to be raised before the arbitral tribunal concerned, and the civil court could not proceed to examine the applicability of the arbitration agreement to the facts of the case. It has to be raised before them. Now, the other judgment my learned friend had referred to is AIR 2000 Calcutta. AIR 2000 Calcutta, page 232.
Yes.
Judgment delivered by Justice Kulanjyoti Shen. Raj Chaudhary was the Union of India. May I place it?
Yes.
Paragraph 20. Mr. Roy contends that there is an agreement between the writ petitioner and the respondent number 2 and 3 for telecasting 500 episodes, and it is admitted so in the affidavit in opposition and further from the letter dated 17 June 1990. I am to accept Mr. Roy's contention that there was an agreement for telecasting 500 episodes. Of course, in paragraph 6 of the affidavit in opposition, it is averred that the proposal of the petitioner for telecasting 500 episodes was accepted in principle, and such acceptance was communicated by a letter dated 17 June 1998. But in my view, the aforesaid admission should be construed as being negotiation. The parties thereafter have found themselves in a written concluded contract dated 25th June 1998. The copy of such agreement has been annexed. It appears from the Annexure A, both the parties have signed. So whatever may be the dealings and negotiation antecedent to this written document, the same cannot have any effect at all, as everything has been settled in the written contract. Now, both the parties are bound to be governed by the written document being annexed to the affidavit of opposition.
No, they are relied upon 19. Para 19.
Paragraph 9. 19.
19.
Yes, having heard the learned counsel for the parties and considering the materials produced before me, it appears to me that there is a question as to whether the writ petition should be entertained in this case, firstly, in view of existence of the arbitration clause. It appears that Justice S.B. Sinha, in his judgment reported in AIR 95 Calcutta, has been pleased to observe that when there exists an arbitration clause, the writ petition normally does not lie. It appears from the language in the said judgment that the aforesaid principle is not inflexible. In fact, his lordship has not, of course, propounded such absolute and inflexible theory that the existence of the arbitration agreement will stand in the way of in exercise of writ jurisdiction. Ordinarily, such course of action is not entertained by the writ court. In my view, the existence of the arbitration agreement is nothing more than existence of alternative remedy, and it does not stand in a different and separate footing also. It is settled law that when the decision of unequal treatment and further complaint of arbitrary unfairness and malafide in state action has been raised, such question can only be effectively decided by the High Court in exercise the power under judicial review under 226 or by Supreme Court under Article 32. In the said decision, it appears that one of the parties had resorted to mechanism of arbitration agreement by filing an application under Section 20 of the Arbitration Act 1940. So factually, the aforesaid case was also distinguishable. In this case, I am of the view, going by the averments of the petition and the submission of Mr. Roy, that petitioner questioned the act and action of the respondent 2 and 3 in refusing to grant extension up to 500 episodes, and or by not allowing the petitioner to telecast up to 500 episodes in conformity with the alleged agreement as being arbitrary and malafide. The question of legitimate expectation in this case has been stated, but based on practice and customs. The question of frustrating the legitimate expression cannot be decided by the arbitration. The question absolutely remains within public law field. I have examined the arbitration agreement. It pertains to the dispute relating to the written contract. In this case, the petitioner canvasses the dispute as stated above. I therefore hold that the petition is entertainable. Why, my lord? 500 episodes beyond 500 brackets were beyond the contract. And then, my lord, the other question is also, my lord, relating to
public law aspect. It comes.
That is another.
Yes.
Yes.
In our case, my lord, the entire dispute is covered. The GST aspect and the PVG is part of the agreement. The rates are different. Rates have changed rates have changed in view of changing in view of law, change in law and the trade circuit, which in any event the arbitrator has to look into.
Okay.
Now, my lord, on the aspect of jurisdiction, today my learned friend has submitted on the afternoon. The page 60 of my section 8 application, kindly take this, the jurisdiction clause.
Yes.
Page 60, clause 11.
Yes.
Jurisdiction of courts. The courts are the place of ownership of rigs by the respective steel plant. Only shall have, this contract is for the purpose of purchase by the Steel Authority of India Limited of rigs. Therefore, my lord, the ownership of the rigs will be of Steel Authority.
Of the
Steel Authority of India. Now, why says according to respective sale plant? Kindly see the concluding part of this clause. Supply of boggle open wagon for BSB at Durg, Chhattisgarh. Supply of such and such for BSL at Bokaro, Jharkhand, and supply of bogie open, etc. for DSP at Durgapur, West Bengal. Therefore, the supplies, a contract is for supply of the wagons to the. Now, when the parties will not agree that the place of ownership of the wagons shall be this, the parties have in their mind at the time of making this agreement that supplies will be made at a particular place. The owners will be the particular plant of these wagons. They have not supplied anything. That is true. No, there has not been ownership of wagons.
Correct.
But the dispute is all concerning totally with regard to supply and ownership of these wagons. Therefore, in humble submission, this clause 11 has to be construed meaningfully so as to mean that the place where it is required to be supplied, the party to whom it is required to be supplied, the ownership will be following with that. The fact that they have totally failed to perform their obligation, that will not change this forum selection. This is a forum selection clause. I am not contending that Calcutta will not have jurisdiction. Part of the cause of action arises because it carries on business. Steel Authority carries on business here also.
Correct.
Because it has its office here. Now, but the question is, when two courts or more courts have jurisdiction, then the parties are free, at liberty to choose either. This is a forum selection clause. Therefore, irrespective of the fact whether Calcutta has jurisdiction or not, this has to be the suit could only be filed at the Durgapur court, Durgapur commercial court, because this is in respect of sale Durgapur plant.
Because the court at the place of ownership of racks by the respective sale plant.
Yes, this is pursuant to the agreement. Ownership will be ownership of the racks is the subject matter of the contract.
Correct.
If the supply has not taken place, but the agreement, this is why this clause has been couched like this, because this is a centrally floated tender. Centrally floated tender in respect of all three plants. Therefore, it says that the point of, I mean the purchaser, particular plant, that is the purchaser. Although Miller is centrally
But they have to sell the racks.
They have to sell. They have not yet sold.
Correct.
But the contract is for sale, and the ownership will be of the particular plant.
Correct.
Now, my lord, on that, therefore, the entire agreement is with the plant, DSP,
Correct.
not my lord Bokaro. Like that. Therefore, the agreement is, my lord, since my lord, as I said, since it is in an auction floated centrally, my lord, if it was done with DSP alone, then the clause would have read something else. But because it would straightway say it is this is Bokaro plant or Durgapur plant, like that. Here, my lord, where the ownership will stand vested. It is a case of, it is a contract for supply. The ownership will arise on supply. They have not supplied. Will that change the forum? My lord, this is the parties intended that the disputes arising in respect of this agreement. This agreement is for supply.
Correct.
Agreement is for supply.
Supply. They have not supplied. There is a dispute.
There is a dispute. They have not supplied. There is a dispute. But then, my lord, the ownership has not yet come with DSP. Does not yet come with DSP. But the purpose of this clause, in my humble submission, is that wherever you are entering with an agreement with DSP now, and therefore the intention is that the DSP, the Durgapur, will be the chosen forum.
So if it is not come to the DSP at Durgapur, so what would be the situation?
The ownership has not yet come.
Correct.
But then the agreement is for transfer of ownership. Transfer has not taken place because of the inaction or fault on the part on their part. Will that change, my lord? An agreed term regarding jurisdiction? Because it is intended, ownership of place of ownership, it says definitely. But why? Because the contract is being entered into with DSP, with Bokaro. Like that.
Dispute is not regarding ownership. Only the courts at the place of ownership shall have jurisdiction over any dispute arising out of respective contract. What a point.
My lord, may I replace this 11? The courts at the place of ownership of Rex by the parties of steel plant shall have exclusive jurisdiction over any dispute arising out in respect of this contract.
That is supply of bogie.
Therefore, the disputes that my learned friend is raising are only all concerned with this agreement. Therefore, over all dispute arising out in respect of determines, my lord, that itself, the dispute, there is a dispute.
Dispute is not regarding ownership.
The dispute about
Ownership is not.
Dispute is not regarding ownership.
Dispute is from the contract.
Dispute is with regard to certain terms of the contract. Therefore,
place of ownership is the co-citus is given. Place of ownership determines the citus of the court's jurisdiction.
Yes.
Citus of the court's jurisdiction, the place of ownership যেখানে হবে. But the dispute is arising from the contract.
Now, 2002 Volume 1 Calcutta is placed. This is Steel Authority of India versus Dinesh Kumar Jaiswal. Paragraph 2, part of it has been placed.
Yes.
The suit is a suit for recovery of damages against Steel Authority, which carries on business within the ordinary original civil jurisdiction of this court. It is on this basis that the jurisdiction of this court has been invoked. Mr. Chatterjee, learned advocate appearing in support of the appeal, has contended that the office of the defendant situated within the jurisdiction of this court has never dealt with, nor had any occasion to deal with, any part of the portion of the transaction between the parties. Then, paragraph 5. This submission of Mr. Chatterjee cannot be accepted for the reason that it goes as to where the cause of action arises as per original side rules. There is jurisdiction. Therefore, my lord, this judgment, my lord, in my humble submission, is not appropriate on this aspect. And clause 60 is wide enough to cover a dispute any dispute arising out of the contract, and not merely, it is not determinable only on the basis of the transfer of ownership.
Yes.
No. Nominal
Yes, sir.
I can give my reply now only I've seen, or if Lordship wants notes, I can give it with my notes on the next
We
day.
do when both the party file return notes of argument dealing with.
And on that day, I shall, or Lordship, may I reply on this, on these judgments? I can, or she keeps on Tuesday, then I can do it along with my notes, or else I can do it just now. Lordship,
If you're ready to run, you can give, then I will fix it.
or Lordship keeps it on, I'm eager to finish it here and now. Can you see, at least Lordship sees the last judgment cited by Mr. Gupta. 1514 SCC, page 21. This office memorandum, subsequent event, this will be a part of the substantive law or trade usage. This is, so far as GST is concerned, I do not join issue with him. Rate is changed, that's part of the contract, I don't join issue. But my main cause of action is the office memorandum. Kindly takes a look at paragraph 39 on page second or third last page, page 44.
Page
44 of this 1514 SCC National Highway Authorities of India.
paragraph
39. 39. Main paragraph is 42.
Yes.
The disputes between the parties were referred to the arbitral tribunal.
Yes.
We are concerned in the present appeal with claim 8, which was for refund of royalty on ordinary earth amounting to 70 lakhs odd, which it claimed on the ground that it was covered by clause 70.8 COPA. It was observed by the tribunal that after the commencement of 57 Act, it was not within the powers of the UP state government to have framed UP state rules, and consequently such rules were not binding on the contractor. In its view, the imposition of royalty by the government by notification being after the central government notification of 3rd February for the first time validly created liability to pay royalty. Any levy and collection prior to 3rd February was within the legal. Now kindly come to paragraph 40. The award was upheld by both the courts. I'm not troubling my law. Kindly come to paragraph 41. 41, 42 is what I'm placing. In support of the appeal, Ms. Indu Malhotra, learned senior advocate, submitted that the royalty at the time the contract was entered into was payable at a rate of 4%. And in the notification of 20th March of the government of UP maintained the same rate. The reasoning that prior to 3rd February 2000, the state government lacked competence and as such valid impact occurred for the first time by notification of 20th March in her submission was flawed and beyond the scope of the jurisdiction of the arbitral tribunal. On the other hand, it was submitted by the respondent that a demand letter from the district collector was without the support of law, and that the impost pursuant to notification alone was valid and legal, and as such it being after the contract was entered into, must qualify to be subsequent legislation. This is his. The question, therefore, is whether Claim 8 is covered by Clause 70.8 of COPA. In Clause 13.4 of the invitation to tender, it was clearly stipulated in the contract that all duties, taxes, and other levies payable by the contractor under the contract as of the date 28 days prior to the deadline for submission of bids shall be included in the rates and prices and the total bid price submitted by the bidder. The state government, as a matter of fact, was levying royalty on ordinary earth, and this situation was obtaining on such date. If the state government lacked power to levy and collect such royalty prior to notification of 3rd February 2000, whereby ordinary earth was brought under the definition of minor mineral, such ground may certainly entitle a party to lay requisite challenge before an appropriate forum. However, for the purposes of the contracts, such levy, being an existing levy, must be deemed to have been part of the rates of price quoted. by the notification of 20th March 2001, the same rate was maintained, and as such, there was no change arising due to any subsequent legislation. In our view, the matter was therefore completely outside the scope of 70.8 COPA. Arbitral tribunal ought to have confined itself to the terms of the contract and see if there was any variation for the purpose of 70.8 of COPA. It went beyond its powers in holding that the existing levy as in the date of the contract was entered into without any authority. And that's as the imposition of notification created liability for the first time. So for that, one to go to the appropriate forum. You can't come to the arbitrator because that is not within the arbitrator's domain.
Yeah.
But this is also the position in the state of Chhattisgarh judgment, Sal Udyog, if Lordship takes a look at the judgment cited by Mr. Gupta. I am relying upon paragraph 14.
Which one?
This 22 SCC. Page 275, state of Chhattisgarh versus Sal Udyog. It kindly comes, this is exactly the law. Paragraph 14, page 282.
Paragraph?
Paragraph 14, it is a quotation from Associate Builders. Paragraph 14 of the judgment, the quotation is from Associate Builders. Kindly come to at the top of page 282, after placetum B. Placetum
the rule applicable.
Rules applicable 28.3.
Yes.
Trade usage.
Yes.
The last contravention must be understood with a caveat.
Yeah.
An arbitral tribunal must decide in accordance with the terms of the contract. But if an arbitrator construes the term of the contract in a reasonable manner, it will not mean that the award can be set aside on this ground. Construction of the terms of the contract is primarily for an arbitrator to decide unless the arbitrator construes the contract in such a way that it will be said to be something that no fair-minded or reasonable person could do. So, terms of the contract alone. Now, Lordship kindly, apropos trade usage, Lordship kindly takes a look at the judgment of Justice Saraf in the Port Trust matter. On trade usage, what Mr. Gupta was trying to show, this may come within trade usage. Lordship kindly comes to that universal judgment. Oh, paragraph number SCC there. Oh, so Lordship I got the SCC copy, na? Give me, I've got still my High Court copy.
Yes.
You just take out the yes, Lordship. Can you give me 1 minute? I will just give the paragraph number. Oh. Paragraph 26 kindly come. Oh, sorry, paragraph 29. Where this Bombay High Court Justice J.S. Gupta's judgment was quoted. Kindly come to paragraph 29 at page 22 of the SCC printout.
Yes.
I find myself in complete consonance to the above view.
Yes.
However, Mr. Ratnako Banerjee attempted to impress upon me that the arbitrator may have alluded to Article 14 of the Constitution and aspects of discrimination, but the award was actually based on 28.3 of the Act, wherein the arbitrator interpreted the agreement while having regard to trade usage. Now, what is trade usage? Lordship kindly comes to paragraph now. 30 is
33.
30, yes.
33.
33.
In the middle.
Lordship. And there is ambiguity. It is not their case that any clause of the contract requires. It is not the plain case. So if it's a claim based on the office memorandum, it cannot be a trade use.
In this case, the arbitrators, the tribunals have considered the other act with regard to the port charges.
Yes.
whether the levy can be given or not, the court has held no. You cannot go to the other act.
Even though it was act.
Act under the what the contract provides, you have to decide on that one.
So when my plaint case is based on the office memorandum, Lordship and especially Lordship sees 20. Okay, act the Lordship sees Section 8 itself. The language of Section 8 is this makes it very clear. Afterwards, will the 8 subsection 1, a judicial authority before which an action is brought in a matter which is the subject of an arbitration agreement. The office memorandum is not a subject of the arbitration agreement. Now, this will not be, so arbitrator is bound by the terms of the arbitration agreement. I'd not join issue with Mr. Gupta when he says GST rate, because GST is payable as per the arbitration, as per the contract.
In the clause, it is a GST or whatever the tax applicable.
So GST rate may fluctuate. My claim that you have asking for excess.
That question has been already decided after the implementation of the GST. Several cases has come.
Yes, well, absolutely.
With regard to the GST, whether it is from the contract date or the applicability of the July 22. So now the court says, as per the applicability of the GST in terms of this.
So if the contract requires GST to be payable, to be reimbursable, the arbitrator, I can certainly raise before the arbitrator that they should reimburse me this much, and the sale is refusing to do so, that will be covered. But that is not my name. My case is 7% to 10% to 3%. That's got nothing to do with the contract. That's office memorandum. In fact, there is a writ court judgment of our High Court where this office memorandum was made applicable to, I think, sale itself. This is not sale, one of the other public sector undertakings, and said that you have to
Writ court can do.
Writ court or suit court can also do, but the arbitrator can never do. That's why the distinction was made in one of the judgments that Section 9 the court may have done, because there the court can do it, because there the substantive law of the land, but the arbitrator cannot do it. So, well, these are the two judgments that 2020 volume 2 CLJ. That copy nahi, that I shall deal with. Maybe Lordship kindly gives them, because that they didn't have a copy, so I don't have the book. Lordship kindly, Lordship kindly keeps it next week. I shall give my note if your Lordship so desires, and I shall in 2 minutes see that judgment, because that I could not see because they didn't have a printout. And but so far these two are concerned. This is these two. The second one is squarely on my point.
So suffering for the petitioner, plaintiff, so suffering for the defendant. Hearing in connection with GS 2 of 2024 filed by the defendant is concluded. The parties are directed to file their written notes of argument within a week.
Within a week, Lordship kindly gives any date.
On the 6th Friday week.
Whenever. Mine will be ready next week.
Within 10 days, let the matter appear on 6th of December 2024 under the heading to be mentioned for filing written notice.
Lordship kindly don't record concluded, because I shall just deal with my. I will just deal with that one judgment of theirs on that. I'm grateful to.
May I take back the book?
You the side.
Great.
Number 14. My lord, in this matter, I am appealing for the plaintiff matter.
Yes.
There was an order for supply of.
Which was the other side?
Lordship, I appear on behalf of the defendant. Lordship, GA5 has been disposed of. They were directed to serve a copy of the plaint that has been complied with. Your Lordship, GA4 is my application for revocation of leave granted under clause 12. Lordship, I'll.
But why?
Lordship,
what is the ground?
Lordship, the ground is that the plaintiff and the defendant and the contract, the plaintiff and the defendant are situated in Karnataka, and the contract was also executed in Karnataka. The only the only pleading taken in the plaint is that it was executed in Kolkata, whereas there are documents to the contrary showing that the document was executed in Karnataka, Dharwad. Lordship, today I'll be seeking an accommodation. Your Lordship, I'm being led by Mr. Bose, and it was, Lordship, frankly speaking, Your Lordship, we are not prepared in the matter. So, Lordship, kindly grants us some time to come back and argue the matter.
My lord, I leave it to your lordship, my lord.
So appearing for the plaintiff. So appearing for the defendant. Defendant has filed an application being GA Com 4 of 2024, praying for revocation of leave and dismissal of the suit.
Lordship,
Praying
leave
for
under clause
revocation
12.
of leave under granted under clause 12 of the latest patent. Full stop. Counsel for the defendant prays for time. It is fine from the record. Pleadings have been completed and matter is ready for hearing. Counsel for the defendant prays for time. In view of the submission made by the counsel for the defendant, case is adjourned. Let the matter appear on 16th December.
Grateful, Lordship.
Under the same heading. Adjourn motion. Next.
May it please, Your Lordship.
15 morning somebody has mentioned.
Yes, Milord, we have been told that Shutapa Madam Milord is not well today. But this is, I leave it to Your Lordship. I was only, Milord, to answer Your Lordship's query that the defendant has not filed written statement. This is the copy of those certificates. It's a suit, Milord, commercial suit. No manner of presence would change the situation. Your Lordship kindly sees the last order. GA2 was filed. There was an order of stay. GA2 was filed by the defendant.
Yet it is disposed of.
It is disposed of. There was a stay. It was disposed of by the order of 31st December 2024.
Misfortune of law and cannot be said to be at this stage. Accordingly dismissed.
Milord, may I indicate 24th of January 2023 was the date when they had received the writ of summons. But that was the period when an order of stay was in operation. That order of stay was, Milord, vacated when the GA2 was dismissed. That dismissal order is 31st of January 2024. So the 120 days period starts running from 31st of January 2024.
Why?
Because there was an order of stay before that.
Stay of?
Milord, stay of the operation of the suit. I had handed over the copy. This is the order by which GA2 stay was granted. That is of December.
That is a December.
Your
Yes.
Lordship, Ms. Shutaba Chanal had mentioned this matter in the morning.
So you are praying for time?
Yes, Your Lordship. This matter can be fixed on Friday.
Friday, I am not there. That's the difficulty. I would have said, Milord, no manner of presence or absence would change the situation. I will not stand in the way.
But
Your Lordship,
morning there.
yes. Milord, I'll hand up a copy of
Which one?
the certificates which I have handed up to Your Lordship to my learned friend. Let them consider.
So appearing for the plaintiff. So appearing for the defendant. Counsel for the plaintiff has handed over the copy of the report issued by the Deputy Registrar within bracket legal dated 25th November 2024 to the learned counsel for the defendant. Let the report be kept with the record. To this court as well as counsel for the defendant. Let the report be kept with the record. Counsel for the defendant prays for time. In view of the submission made by the counsel for the defendant, case adjourned.
But may it be kept on the first, Milord. 6th, obliged.
6th December under the same heading. Next.
My lord, Your Lordship, I am for the appellant. Patent appeal, Your Lordship. The learned counsel from the Delhi, Your Lordship, has already completed a submission. It's still part-head matter. Your Lordship, they are supposed to begin their argument today.
My lord, I am hearing for the respondents. We could not get any instructions from the concerned department, so we need 2 weeks more time.
2 weeks more time.
Yes.
Then the court will
Adjourn twice, Your Lordship, this matter.
What is the
part-head
matter?
This is regarding, Your Lordship, the rejection of the patent, Your Lordship, application.
What is the patent?
Medicines, Your Lordship. I don't know too much about the matter because she came and Your Lordship argued. And Your Lordship, she relied on certain judgments also regarding that, Your Lordship.
Yes.
Application and all.
Sir, I am not brief in this case. My
Nandlal
senior,
Singhania,
senior
he
Mr.
was
Nandlal Singhania is appearing, but he is presently busy in some other court.
Let it become tomorrow, Your Lordship. Otherwise, 2 weeks' time is too much.
Sense suffering for the appellant. Sense suffering for the respondent. Counsel for the respondent pays for time on the ground of senior. Accordingly, for the interest of justice, the case is adjourned. Let the matter appear on.
She will fix any time, Your Lordship, so that the matter can be completed. It's a parted matter.
Time is the difficulty.
11th or 17th, whenever Your Lordship diary suits, Your Lordship.
Time है क्या? 17 दिसंबर में
17 দেখুন না তাহলে ও ওখান থেকে দিল্লি থেকে চলে আসতে পারবে আর কিছু না 3:45
17th December 2024 at 3:45.
Item 17 and 18, Your Lordship, this is commercial division matter. Your Lordship, now Your Lordship, it has to be transferred before the IP division. After Your Lordship, the IP division, Your Lordship, has come. Contempt application will be remain here. But
Today
Your
is for contempt.
both, Your Lordship, there is contempt application as well as, Your Lordship, the main suit has come. The other side has not filed any written statement. So that's why, Your Lordship, and we have also obtained, Your Lordship, the reports in connection there too.
Whether a rule issued?
Lordship, the rule has not been issued, but we have served, Your Lordship, the copy. So main suit, Your Lordship, we are expecting if the main suit can be decreed, Your Lordship, then
You have not submitted the requisition for drawing up the completion of the order.
Lordship, that we will do it, Your Lordship.
Did not
But before that, Your Lordship, is a contempt in a CC.
That's why CC come 6 of 2024.
Yes, Your Lordship.
You are not filed the requisites.
We'll file the requisition, Your Lordship. Sometime, Your Lordship, may be given to us.
Today's the suit is there.
Yes,
Where
sir.
is the suit?
The next item, Your Lordship, is the main suit.
Okay, let me out pass this order, then I sense suffering for the petitioner / plaintiff, none appears on behalf of the defendant and full plaintiff. By an order dated 23rd of September 2024, this court had issued rules upon the alleged contemners and also given the liberty to the plaintiff to send the notice of contempt by speed post. Full stop. The Registrar of Ordnance has submitted report wherein it reveals that the plaintiff has not submitted the requisition for drawing and completion of the order for issuance of rule dated 23rd September 2024. Counsel for the plaintiff prays for time for taking appropriate steps for submission of a requisition in the department for drawing up and completion of the order for issuance of rule. In view of the submission made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 17th December 2024. In the meantime, full stop. The plaintiff is directed to take appropriate steps for filing requisites in the department for issuance of rule on or before 6th of December 2024. Please the matter 17 December. Do second one, 18, huh? Sense suffering for the plaintiff. This court find that the suit filed by the plaintiff is connected with the intellectual property matter and filed in the year 2024. Thus, this court is not having determination to hear the suit. Accordingly, CS Form 15 of 2024 is released. An interrogatory application along with this.
Your Lordship, the application has already been disposed of.
Released
The
from,
suit.
from the list of this court. Full stop. The department is directed to assign a new IP case number in the suit and to place before the appropriate bench having determination. Next. Yes.
Madam, for the defendant number 1, my lord.
I appear on behalf of the plaintiff. In this matter, your lordship will recall Mr. Jishnu Chaudhary was leading me. The small point involved was where there are contracts between the parties of deed of guarantees, which clearly specifies that the guarantee is restricted to the value of a property that was situated in Delhi. And thereafter me selling the property, the bank having appropriated the money, whether the bank can cannot issue an NOC in my favor. But will recall Mr. Rudraman Bhattacharya was arguing on the other side. He had completed and he had cited judgments, which I am to distinguish. Your Lordship, I am being led by Mr. Jishnu Chaudhary. I have been told he is on his way. With your Lordship's kind leave, may I just begin with the arguments, or if your Lordship is of the view that Mr. Chaudhary should be doing it, then I can, your Lordship, I'll ask for a short passover.
Passover.
Very well, Lordship. Grateful.
Next. Passover. Yeah, it is 3rd October for witness section.
Item 20.
Item 20, yes. Witness present?
Yes, my lord.
Introduce.
Yes.
Yes.
Lord, I'm for the plaintiff.
This matter?
Yes.
Where is the witness?
Yes, yes.
No, this is a suit for recovery of price of goods sold and delivered.
I filed the exam affidavit.
File an affidavit. Affidavit to দাও আপনি পেছনে কোথায় গেল এটা নাও না
Take the news of that.
Last order, if your lordship is pleased to.
Judge's brief of document.
They have been prepared.
Yes. Bring the witness and doc. Where is the witness?
There is affidavit. Affidavit ওটা কোথায় দাও আমি I'm just to prove the affidavit before your lordship. The affidavit evidence. I'm not the.
There are documents.
There are documents not for which your lordship has been pleased to. We have prepared your lordship's brief of document.
Huh?
In the affidavit, the documents are referred to.
That's correct, but the original is to confronted to the witness. Then it will be exhibited.
Exactly.
Let the original be confronted to the defense.
Yes, most certainly. দর্শককে কি এটা দিয়ে দাও আছে
Are you for the first time?
First time. Your lordship's brief have been filed in 2 volumes.
Okay.
I'll only prove the relevant documents.
Yes.
Yes. Hello, hello.
Okay, repeat after me.
Hmm.
I solemnly affirm
I solemnly affirm
that whatever I depose
that whatever it is,
by way of evidence,
by way of evidence,
I shall speak the truth.
I shall speak the truth.
No part of it shall be false,
No part of it shall be false.
and I shall not conceal anything.
I shall not conceal anything.
What is your name?
Tapan Banerjee.
Tapan Banerjee. Tapan
Banerjee.
Father's name?
Somebody let Mohit Mohan Banerjee.
Library
Late
that once you
Mohit
have
Mohan
Banerjee.
Banerjee.
5 years of practice, don't
Today,
appear
sir?
in an undefended.
63 now.
63. Occupation?
Service.
Service.
Those, but my
Residential
land friend said
address.
that I have to be here, so I'm here.
94
94.
Sunit Banerjee Road,
Sunit Banerjee Road.
Post Office,
UNIT Sunit.
Sunit Banerjee Road,
Post Office.
Post Office, Ghola Bajar,
Ola Bajar.
District 24, Parganas North,
District 24 Parganas North.
Kolkata 700111.
700 Yes, sir.
But may I get that affidavit evidence to be? Should I give you lots of another copy?
No.
এটা রাখুন আমি কয়েকটা কোয়েশ্চেন করে প্রিলিমিনারি করব Now, Mr. Banerjee, how we are occupied at present?
I am working with BST Infotech Limited.
BST
By the expression BST Infratech
Limited.
By the expression BST Infratech Limited, do you mean the plaintiff in the suit?
Yeah.
Yes.
Since when you are with the plaintiff company?
I had been in last 15 years, 2009.
I have been less 15 years. Less 15 years from 2000?
2009.
2009.
In what capacity you have joined the plaintiff company?
I was in assistant general manager. Now I am GL manager marketing.
Assistant general manager.
Now I am GL manager marketing.
Now I am GL manager marketing.
Are you acquainted with the facts and circumstances of this case?
Yes.
Would you please tell my lord briefly what is the case about for which the plaintiff has filed the suit?
Actually, we got some inquiries from this Gammon Limited. I got some inquiries from Gammon Limited.
From
Gammon Limited.
Gammon Limited.
Gammon India Limited.
Gammon India Limited.
Gammon India Limited.
After that, we have quoted most competitive price and got the order.
What was the material that you were to supply to Gammon Engineers Contractors Private Limited different in the suit?
This is metal beam crash barrier.
Metal beam crash barriers.
Are there any document to substantiate your statement, your evidence before the court, before the honorable court, with regard to the subject matter of the suit?
Yeah. Yes.
Don't
yes.
say yes.
Sorry. Yes.
Please say yes. Yeah is only in the rock.
Yes.
I am showing you a document.
Sure.
I am showing you a document. Can you identify this document?
Yes.
What is this document?
This is the this is called shoot. Whatever we have declared. What is the case history and all these things.
Who is this document? Who is this document signed by?
This is signed by me only.
And when?
It is signed. I think the date was there. Like 20th August 2024.
20th August?
Signed the document on 20th August 2024.
Yes.
I am drawing. একবার দেবেন কি কাগজ দিয়েছো আমার সঙ্গে মিলছে না I'm drawing your attention to page 21 of this document. Do you find any date at the end of paragraph 37 of this document?
Page 21.
What at the end of paragraph 37?
30th day of September. Yes, I have seen.
Yeah,
2024.
30th September 2025.
Are this affidavit of evidence affirmed by you, the content thereof are true and correct?
Yes.
And may I tender that affidavit? But then do I have to go through the documents also?
You place the document wise, only it will be exhibited.
Okay.
Original.
The volume of documents, I shall skip many.
Sure.
All those are referred to in my mallet affidavit evidence.
So serially you place it, it will be exhibited.
I am grateful to your Lordship.
No, exhibit.
I am showing you a document which is dated 5th December 2019. Can you tell my lord what is this document about?
This is the work order copy.
Please.
This is a work order copy issued by this Gammon.
Not so far those the discussion partner, I shall put them in a bunch with regard to the placement of the order.
Yes.
I am showing you another document dated 7th March 2022. Can you identify the document and tell my lord what is this document about?
This is another work order issued by, this is amendment order. This is amendment order. Original orders, amendments.
Who issued this amendment order and to whom?
This is Gammon Engineers and Contractors issued this amendment order to BST Infratech Limited.
Gammon Engineers and Contractors Limited issued this amendment order to
BST Infratech Limited.
BST Infratech Limited.
Lord, may I Lord, exhibit them collectively?
Exhibit A.
A.
Yes,
Next. I am going serially. What?
That will be better.
Here, my lord. I am showing you two documents, both dated 21st March 2022. Can you please look into the documents and tell my lord what are these documents about?
This is also the draft copy of supply order. Draft copy of supply order.
There are two documents.
Yeah.
Please tell my lord what is the draft copy of the order and what is the next document.
This is the work order for 4 mm dia galvanized mild steel wire. They have issued one order.
4 mm
4 mm dia mild steel.
Dia spelling, sir?
TIA.
TIA.
Mild steel galvanized
wire
for 100 metric ton quantity.
for 100 metric ton quantity.
Price is also there.
Lord, may I tender the document collectively?
B collectively.
Pursuant to the work order issued by the defendant to the plaintiff as we have deposed, did the plaintiff supply the materials as ordered for?
This where there is 4 mm wire and crash barrier, metal beam crash barrier also, both items.
ওটা আগের আনসারটাই হবে, তারপরে কোয়েশ্চেনটা করব।
Crash CRASH.
Barrier B double R.
Crash barrier.
Also.
Pursuant to the purchase order sent by the defendant, did the plaintiff supply the materials as ordered for?
Pardon?
বলে দিন তো।
Yes, as per the order, we have supplied the materials.
Was there any occasion for the plaintiff to issue, to raise tax invoice upon the defendant in respect of the goods supplied?
Tax invoice we have issued.
Tax invoices were issued.
We have issued.
May I tell you on মাথা নাড়বেন না, মুখে বলবেন. Nobody is following your gesture. মুখে বলবেন.
Tax invoices were issued. তারপর বলেন we have invoiced. Tax invoices.
I am showing you a document dated 24th December 2019. Can you identify this document?
This is a copy of invoice, original tax invoice.
And may I tender the document?
Exhibit C, my lord.
Collectively করে দেবে না? No, ওটা single.
Single.
I'm sorry. I beg your pardon. I'm showing you two documents issued by Olok Transport Private Limited. Can you tell my lord what is this document about and what relation these two documents have with regard to the suit transaction?
The Olok Transport is our transporter. They have transported materials.
Sir,
This is
slowly. Olok Transport is our transporter. They have transported our materials. বলুন.
This is a consignment copy.
This is a consignment copy.
Did the plaintiff receive this consignment copy in their usual course of business with the transport company?
Usual course of business. Normally, they have already received the materials. Here is the receipt.
They have already received the material.
Here is the receiving of the materials.
We'll tender the document collectively.
D. Collective. Yes, next.
I am showing you another consignment. Another document dated 21st January 2022. Can you identify this document and tell my lord what is this document about?
This is another consignment note to which we have sent the materials supplied. This is the transporter's consignment note copy.
This is the transporter.
May I tender the document? May I tender the document?
E. Yes.
I'm not. There is another one. I will do it in the same transport company collectively. Hello, আপনি একটু রেখে দিন. I'm showing you একবার ডকুমেন্টটা দেবেন. এটা দিন. এই document. I'm showing another document of SRL Logistics dated 22nd January 2022. Can you tell my lord what is this document about?
Another copy of this consignment note for dispatching the materials.
May I tender the document collectively?
Collectively. पहले जो था ना उसको नीचे एक दोनों के एक साथ कलेक्टिवली
No, there is another consignment note. I put that question and let it go along with those. এখন মার্ক করবেন না. Can you identify this document?
Yes, this is another consignment note for transporting this material, dispatching the materials.
আরেকটা দিচ্ছি. কি পরপর দিয়েছিস? অসুবিধা হয় বুঝতে পারিস না. I am showing another document dated 17th March 2020. Can you identify this document? একসঙ্গে দিবি তো সব ট্রান্সফার পরের পর কি দিচ্ছিস কোর্টের কত অসুবিধা হয়
This is also another consignment note for dispatching these materials.
I am showing you another document of like nature. Can you identify this document?
This is the original copy of that earlier one.
May I now tender the document collectively?
collectively.
Original which is copy of it. অসুবিধা হয় কত বুঝতে পারি কিছু জানিস না ইয়ে করছিস
Yes, next.
I am showing you 4 documents. Inter are dated 21st January 2020, 22nd January 2020, 18th January 2020, and 29th February 2020. Please go through this document and tell my lord what are this document about. And another one. And also another one. Bhai, date to add kore neben. And 17th January 2020. Right. তাই না আমার ভুল হয়েছে আর একটাও কাইন্ডলি দিয়ে দেবেন should have been 1 month আর 28th May 2020 কোর্টের অসুবিধা আমাদের অসুবিধা
These are all the original tax invoice copy.
Raised on whom?
Raised to Gammon Engineers and Contractors Private Limited.
And pay may tender the document collectively.
Have collectively.
If collectively, my lord.
Have collectively. Yes.
ये भी I am showing you I am showing you 6 documents. Inter are dated 23rd March 2020, 27th January 2020, 30th February 2019. এটা একটু আগে করে দেবেন kindly. 6th March 2020, 28th January 2020, and 3rd June 2020. আপনি একটু chronologically kindly করে দেবেন এখানে এত haphazardly আছে না Can you identify this document and tell my lord what are these document about?
These are all the e-way bill against this invoice what we have supplied the materials. This is e-way bill.
ভাই আরেকটা নিয়ে নেবেন kindly. I add another one of the similar nature. 29th June 2020.
See the document.
This is e-way bill.
G collectively. Next. G collectively. G collectively.
I am showing you a document dated 23rd June 2020. Can you tell my lord what is this document about?
This is also this invoice, tax invoice for supply of this GI ware for another order, second order. Second order.
Now, what was the total amount of goods or goods that you have dispatched to the defendant as per their orders, which you have identified earlier?
Total value was around 55 lakhs is outstanding. That much I have.
Since when it was outstanding and or payable by the defendant to the plaintiff?
From this 2020, 2022.
With regard to the amount which you have given credit to the plaintiff, to the defendant, and the balance is 55 lakh 2,428, is rupees 55 lakh 5502 428. How the balance payments, how the payments were made by the defendant to the plaintiff?
They used to make the payments by check only or RTGS, and they are supplying part payment. They are paying the part payment partly, and they are asking for supply of further materials. We have supplied the materials.
Slowly, sir.
You follow the pen.
You were asking for supplying of materials,
And we have supplied the materials.
and we have supplied the materials.
They are making the payments
They were making their payments
time to time.
time to time.
But last supply, they have stopped payments.
After the last supply, they have stopped the payment.
The payment that were made, payments those were made by the defendant to the plaintiff, where they were kept by the plaintiff.
Pardon?
May I withdraw the question, Lord? The payments were made to your banker?
Yeah, directly. Sorry. Yes, sir. Directly make the payments through banker.
Who was your banker?
UCO Bank.
Did the plaintiff have any bank account with the Allahabad Bank?
Yes, Allahabad Bank is also there. We are having three bankers: Allahabad Bank, UCO Bank, and Oriental Bank of Commerce.
UCO and Oriental Bank of Commerce.
I am showing you three documents. Can you identify these documents? May I tender the document? Sorry.
I am going to see documents. Can you identify? Showing the bunch of documents. কিছু জানিস না সুখী করতে হবে।
These are all Allahabad Bank statement, which we have supplied, which we have submitted to you for this proving this payment.
We have submitted for proving the payments.
May I tender the document?
I collectively.
Opening balance. I am showing you a document. Yes. A document pertaining to the period 1st April 2019 to 9th October 2020. Can you identify this document and tell my lord what is this document about? A demand notice bar kar.
Our company ledger, accounts ledger of the said company, of the our client for showing the payments and
Did you-
outstandings.
Did you have anything to do with the preparation of this? Did you have anything to do with the preparation of this ledger that you have identified now?
Yes, we got all this information from bank accounts, and accordingly we have prepared this ledger.
Let me attend to the document. এই ডিমান্ড নোটিশটা দাও আর ওদের একটা চিঠি দাও। আই এম অলসো ভাই ওটা এখন করবে না, আরো দুটো আছে লেজার একসঙ্গে করে দেবো। Please look into these two documents also and tell my lord what are these documents about. ডিমান্ডটা বল এবার। আরে এখানে তো চাই।
Both are this Gamon's accounts ledger.
Yes.
Gamon engineers.
May attend to the document.
Okay.
Now with regard to your kindly করে দেবেন, আমি মিস করে গেছি, এত হ্যাপেজার্টলি ডকুমেন্ট আছে না, it is difficult to এরা জানি না সুট কিছু। Now with regard to your outstanding that you have deposed before my lord, which was to be recovered from the defendant, I am showing you paragraph 31 of your affidavit evidence. Is this the amount which stands unpaid by the defendant to the plaintiff?
Yes, this is the 55 lakhs 02,428. This is the amount outstanding from this.
Now, with regard to your outstanding amount, which you have just now told, my lord, did the plaintiff raise any demand upon the defendant?
Yes, one interest we have raised the demand, and
Yes, we have raised demand along with interest.
কোনটা বলো? বার করো।
and damages charges also 20 lakhs rupees.
Damages charges also.
একটাই দাও না।
Yes, next.
দিচ্ছেন না কেন?
একটা হবে, স্টেপলার হবে। আমি শেষ করে নিই, তারপরে কালকে ভোর
Will only you wanted to cross the witness.
Oh, that you can. Now, I am showing you a document dated 4th March 2021. What is this document about? Sorry. The page
This is a legal notice we have sent.
Who sent
on the demand?
Who sent the legal notice?
Advocate Mr. Shambhudat Datta.
Who instructed Mr. Datta to Datta advocate to issue this notice?
We instructed Mr. Shambhudat Datta to issue this notice.
Are the contents of this demand notice true and correct?
Yes.
Is the demand notice signed by Mr. Datta, the advocate?
Yes.
Are you acquainted with his signature?
Yes.
Let me tender the document.
Yes. Okay. Yes, next. How many documents?
No, they মানে আর আছে কিছু ব্যাংক স্টেটমেন্ট আপনি কিছু দেওয়া ধরেন ডিমান্ড করেছো may I tender the demand notice?
Yeah, already tendered.
I've tendered. Now, pursuant to the demand, notice that the plaintiff sent to the defendant through Mr. Dato, the advocate. Did the defendant make any payment?
No, after that they have not made any payment.
And plaintiff copy is also plaintiff copy is also. May I show him the plaintiff? And then please come to paragraph 30 of the plaint at page 13 thereof.
Yes, sir.
Yes.
You find that along with the claim being the outstanding amount at rupees 55 lakh 55
lakhs,
comma 55,02428.
Yeah.
You were also claiming interest at the rate of 18%. Do you see that?
Yes, we have claimed.
Is there any agreement between the plaintiff and the defendant to pay interest on the unpaid dues of the plaintiff?
Actually, we are financed by bank, and whatever the outstanding is there,
We were financed by the bank, and
whatever outstanding is there,
whatever outstanding is there,
we have to pay
we
the
have to pay.
interest to our bankers also. So naturally, we have charged the bank rate of interest on
We have
outstanding.
charged the bank rate of interest.
Bank rate of interest on the outstanding.
On the outstanding.
Now, do you find that the plaintiff has also claimed damages to the tune of 20 lakhs? Would you please tell my lord what is this claim about and how do you quantify this claim?
We have claimed 20 lakhs damages as we are not able to make the business with this amount. This is 55 lakhs to since last 3 years, and we have lost a huge amount of business, and we are not able to pay the earnest money deposit for attending tender also. So we lose various orders.
Do you also find that the plaintiff is claiming loss of expected profit quantified at rupees 10 lakhs? Now, with regard to this claim, will you tell my lord how did you compute this claim?
Because in this period, if we got this amount, we can make
In this period, if we got that amount,
the business, and we could have earned 20 to 25 lakhs
25 lakhs
within this period. So we have only expected 10 lakhs rupees as the compensation.
No, that's all, my lord.
That's all. Yes.
But kindly fix another date for us for doing the cross examination.
So and so suffering for the plaintiff. So and so suffering for the defendant. Full stop. Plaintiff witness is present. And full stop. The plaintiff has filed the exam affidavit of evidence and judge's brief of document in 2 volumes. Let the same be kept with the plaintiff witness is examined. And during his examination, exhibit A2.
Lord, one more document which I missed, my lord, which shows the part payment was made. I want to put that as a.
Next, I am deferring.
I will do that.
I am deferring. I am not closing it.
Oh, that's right, well, that's right.
A2K, full stop due to paucity of time. Examination chief is not concluded. No, examination chief is deferred. Let the matter appear. How much time will take for cross examination? No WS, formal cross examination.
That point I have.
Formal to cross examination. Hey,
But at
date
least
दिए?
an hour, more or less. But after going through and ascertaining all the documents, I can only say, at least 1 hour fairly.
Yes. What time? 20 December at 3 p.m.
Grateful to us. Witness will come on. Witness will come on
Yes,
that.
yes.
Grateful to us.
For further examination chief and cross examination.
I'm grateful.
May it be on 22nd December instead of 20 minutes.
22nd December, yes. 10:30 to 4:30. Ready?
23rd.
23rd time is, I don't think that you will get any time. 23rd and 2 p.m. 23rd, Mr. Strategy,
No problem.
2 p.m.
I have no problem.
Lordship, may I have your Lordship's indulgence to
Yes, yes,
mention
yes.
item number 22, my Lord?
Yes.
My Lord, this is,
one.
this may
I'm
be
appearing
taken up
on
in the
behalf of
second
the
half.
defendant.
I have some difficulty. I will not be here. My Lord, this matter was specially fixed on a particular date when we could, it was not taken up. My Lord, I'll beseech your Lordship to fix a date and time. It will take some time. 2 applications are there.
December 3 p.m. That will
I'm
3
deeply
p.m.
appreciative.
I'm for the defendant number 345 in the matter.
Record an order. Item number 22.
My Lord, I'm led by
So
Mr.
give the
Thakur.
appearance, huh? So. As per the prayer made by the counsel for the plaintiff, let the matter appear on 20 December 2024 at 3 p.m.
I'm deeply
Appear on
obliged.
behalf of heavier lordships.
Yes.
Item number 35. It's an IP matter.
Hmm.
It's post 20 also.
Hmm.
So perhaps
I will transfer, release.
yes. And it's an undefended one. No one has filed any written objection. The affidavit
Item number?
35.
Okay, you do one thing. I will call the matter after lunch. If it is not reach, I will.
My Lord, may I be permitted to mention item number 21, my Lord?
Ah.
I'm on behalf of the plaintiff, my Lord. I'm humbly seeking for a not today.
Why?
My Lord,
The defendant. Defendant is not there. I will come after lunch. If it is not, I will sit with them because other party is not there.
obliged, my Lord.
the final part of the order
confirm by returning copies of the statement. Yes. By mentioning to balance brought forward. So money lent or money given, this is the balance which is brought forward. Now next page. So in their books, this is the money which is shown to be due to me. It's a clear confirmation. Okay. Now, my lord, my learned friend says that whether it's a loan is in grave doubt because there are agreements and these are agreements